study.
My lord,
Make a mention soon. That your revision application is taken up.
my revision application was dismissed for default.
All right, I understand that. So many revision applications have been pending under the impression that the person is no more interested. So whenever, for all the members of the bar, in such cases which have been dismissed for default, just bring that to my notice. Those cases shall be restored and shall be taken up.
Now, in my case, my lord, the lawyer expired, my lord. For which, my lord, he could not.
That will be restored.
All right. So on the next date, whenever the matter is listed, you come prepared on the merits of this case also.
I will be pardoned, your lordship. This contempt petition, the order dated 1/9/2023 has not been complied till date.
Give your slips, please.
My lord, yes, contempt matter of 2022.
Give your
Last occasion, I have to mention your lordship has accepted my
accepted or not, I don't know.
My lord, 72.
Content matter.
Give your slips. Give your slips. First of all,
Contempt matter.
again, this is for all the members of the bar. I am taking up those matters where disposal of representation has been directed. So once those matters are disposed of, I'll take up such matters like in relation to pensionary benefits. So you can make a mention, any member of the bar, that relates to pensionary benefits of a retired person, and then similar matters. So those cases will be given preference. And see, there are so many 10,000 contempt applications pending. So we are struggling with the pendency. But whatever is possible shall be done. Please give your slips.
Pardon to mention.
Give your slips. Please give your slips.
Pardon to mention. In the supplementary list, I want to I pray for withdrawal of item number 175.
All right, give your.
I am in the virtual mode.
All right.
I may be pardoned, my lord.
175.
175.
178 has been complied.
178. Complied.
My lord, I may be pardoned, my lord. In item 211, the matter has been listed number of times. This is a matter concerning a compassionate appointment of a rehabilitation assistance scheme. May I pray for taking up the matter, my lord?
175.
I'll take up 111. Huh? I'll see. Not in the next. See, has taken up.
211.
ଗୋଟେ କହିଥାନ୍ତି ମୁଁ ରିଟାୟାର୍ଡ ହେଇଗଲିଣି ମେ 24 ମୋର କୋର୍ଟରେ କେସ୍ ଗୋଟେ ଥିବାରୁ ମୋର ପେନସନ ପରେ ଆଜି ଯାଏ କରୁନାହାନ୍ତି
Pension.
ଯଦି ସେଇଟା ଟିକେ
Which department?
veterinary department
कौन सा department?
veterinary department
Veterinary. You retired
retired
and you are not getting pension.
नहीं सर
Why?
सर प्रोविजनल पेंशन देउଛନ୍ତି ମୁଁ पेंशन पर देउନାହାନ୍ତି एटा केसटा फाइनल रिन्यूअल
क्या है?
So he says that he is getting provisional pension and final pension not being given because the case is pending. Which case is pending? Who case pending? Writ application. A writ is pending, or he says for
contempt
contempt. Then you can give it. Not I look into it.
Give the slip to him and come again on next Friday. Next Friday, you please come again.
Item number 23 and item number 103. Not places in those. Weekly list press admission item number 1. CUNTC 6364 of 2020.
In this case, direction was to regularize the service of the petition who are serving as DLR for 25 years. But they have, after the order was passed, they have brought him over to the work charge establishment.
You can challenge that. Cannot
He
be
has
said
been
to
brought over to a workers establishment. Regular scale of pay is being given.
Yes, my lord.
Whenever he comes to a case for consideration, will be taken up for regulation.
He retired, complete, attend age of superannuation and June 25.
All right, you can,
Liberty,
huh?
liberty to avail appropriate remedy.
You can be complied with.
Item number 2. Item 2.
Who has been complied with lawsuit?
No one appears complied with.
Item number 3.
Complied, lordship.
Complied with.
Item 4.
Who is also not complied with lawsuit?
Welfare states that the order has been complied with. Then counsel for the appeal.
Who is, in fact, not, there was a direction, two sets of directions. First part we have complied with, the sent all in records for the pension. And now it is pending with the upside issue. So lawsuits can dispose of, or lawsuit says that I can,
I'll keep this matter pending.
then the lawsuit 2 weeks after I can obtain instruction regarding full compliance.
This matter on 2 weeks so as to enable an additional advocate general, and the AG to seek instructions as regards full compliance of this court's order.
Item number 5.
Now, 5 has been complied with.
No.
I,
Not
because we have approached the Honorable Supreme Court, SLP in against the writ appeal. Now, so it's pending before the Honorable Supreme Court.
Pending.
Well, only he has SLP has been filed since April 2024, but without any defect, removal of the defect. Now he is only kept in
SLP is pending.
unnecessarily. So then later will come contempt petition lie over
What was the order?
files.
Say, annexure 2, my lord.
This 13175.
3175. This means that the order dated 20, page 20 is in the contempt petition.
That is
Yes.
Yes.
Original order of authority. Original case of contempt.
And this is the order of Retiral WPC.
Contempt
It's
order.
not an order. Order is at page
Page 10 minor annexure 1.
10. So what is the operative part?
People also come to page 16.
Yes.
What the end? Not so. 7 paragraphs above. It's on the lawsuit is. This court further direct, in the event the petitioner gets appointment on redrawal of fresh selection list, the petitioner be treated to have been recruited in the post of contractual Hindu teacher in the year 14-15. And so far as area is concerned, it shall be calculated notionally. However, the other entitlement provided to the similar situated person during period shall be calculated, and for the purpose of fixation of scale of pay. This was the direction. Against that, the writ appeal was filed, and after dismissal of the writ appeal, SLP is pending before the Honorable Supreme Court.
Where is the writ appeal order?
No, the writ appeal. So
Do you have a copy of the order passed in the?
W minor 967 of 2022, my lord.
Limitation.
In the above view of the matter, this court is not inclined to entertain the writ appeal at this belated stage.
Billet.
As the same.
All right.
ground of limitation. Surama.
Referring to the.
SLP pending. Sorry.
Surama Manjari Das.
Sorry. Yes. No, no, we will, SLP is pending.
Yes.
We'll wait for the decision. Drop.
Item number 6.
Contempt proceeding drop.
May I submit on behalf of Mr. Patnaik, my lord? May I submit on behalf of Mr. Patnaik?
Yes, whether order has been complied with or not.
No, my lord, it has not been complied with. No, not complied with.
Yes.
No, sir, file the show cause affidavit. Sir, kindly come to the order passed by this Honorable Court.
Yes.
This Honorable Court's order is
Page 11. Paragraph 3. Considering the allegations involved seriously affecting the frontage of the petitioner's own land.
This is 4134.
Yes, my lord.
4134.
Yes, my lord, sorry.
Yes.
Page 11,
Sir, which page you are referring to?
paragraph, page 11, paragraph 3, my lord.
Just.
Considering the allegations involved seriously affecting the frontage of the petitioner's own land and having no other way to get out of the plot involved, this court in disposal of the writ petition directs the collector.
Sorry, no contempt is made out.
No, my lord, this honorable court is directed to complete the entire exercise within the period of 2 months, my lord.
Yes, yes. No opportunity was given. On the very first day, the writ application was disposed of.
Yes, my lord. Thereafter, they filed the show cause saying that yes, there is an encroachment, and they filed the show cause reply
Sorry, sir.
that there is encroachment, my lord.
The writ petition. WPC number 4102 of 2022 was disposed of on the very same day when it was taken up by an order dated 17/2/2022. So the present application, contempt application, the petitioner has alleged disobedience of this court's order. First off, by the said order dated 17/2/2023, the writ petition was directed to be treated as a representation for the purpose of consideration of the petitioner's grievance. First off, the grievance of the petitioner has been considered, and
Only demolition notices have been issued, but the encroachment have not been removed.
thereafter notices have been issued for demolition of illegal
Encroachments, yes.
Softland Council appearing on behalf of the petitioner states that the encroachment have so far not been removed. First off, I am not inclined to entertain this application, as in the court's opinion, after inquiry, the authorities have taken steps for removal of encroachment. First off, who had encroached?
But some 9% we are not alleged, but we have found that 9% have encroached.
The
And we have-
persons who had allegedly encroached the land were not impleaded as parties.
No, they were never in.
Parties in the writ petition. First off, next, no case of deliberate disobedience of this court's order can be made out in the facts and circumstances is made out. The facts and circumstances noted above, the contempt proceeding is dropped. Yes.
7 is similar to item number 5. SLP is pending. 5 SLP.
Yes,
Item 8,
Liberty.
yes.
item number 8.
8 has been complied with. What? No.
Complied with.
এটা আপনার কোন মিস্টার আসছেন আপনার পুলিশ ডক্টর মানবী সাহিত্য হ্যাঁ I'm giving a copy to my friend.
Complied with. Yes.
Item number 9.
I'm giving a copy to my friend. He has been sanctioned the amount.
Item 9.
Item 9 is not been complied with.
My lord, if any
Yes, there's liberty.
complied, my lord,
You will have the liberty.
maybe I will check everything and thereafter.
If you want to challenge that, there was direction for disposal of representation.
No, there was a direction to sanction. There was a revise where which has been extended to him. Had annexed there. I will give him a copy. The sanction order.
When was the sanction order passed?
No, sanction order was passed. No, 20th June 2024. No.
So whether the payment has been made?
No. No. In that event, I will obtain instruction whether
1 week.
yes.
And maybe fix.
Yes, it will come after a week.
Not.
Item 9.
9 has been completed. I have given a copy to my friend.
Complied with liberty.
Item 10.
Okay, the moon to get a payment.
Item 9, not complied, because item 9, the great pay has to be sanctioned, and the next item 11, the family pension has not been released, my lord,
Yes.
till date. 10 हो गया, 10 हो गया.
When rate of 10 is 10.
So in this case, they have sanctioned, but they have not been disbursed, my lord.
So what is the, which order has been complied with in your case? Item number 9 or in one of the?
No, item 9
He is saying 10.
10.
In 10.
Ah.
10, what was the direction?
Order dated 27/10/2021.
Yes. What was the direction?
Direction is to consider by representation, my
A
lord.
representation.
Ah, they have sanctioned the great pay.
Representation, only order was consideration of your representation. That has been done.
No, no. They consider and give the sanction the great pay, which is entitled, but that has not been disbursed.
They will do it. Not a contempt. Compared with.
Item 11. In item 11, the family pension, in that case, the family pension has not been released.
Whether representation or not.
No.
It is not a, yes, Mr.
Yes, I filed a complaint affidavit.
Okay, compliance test, sir, agreed. First, they solve the compliance bill so that we can go through the compliance affidavit and,
Just a minute. Let me see the order first.
sir.
The pension, family pension papers of the petitioner has already been sanctioned and sent to the authority since 2022, my lords. It was sent on 17/11/2022, my lords.
But till date, he is not getting anything.
Mr. The problem is
Sir,
that such orders were passed on the very first day when the writ petition was taken up.
in presence of the state council, ma'am.
Yes,
Sir,
presence of council is not enough. On the first day, either the writ petition can be disposed of, can be dismissed, or you can withdraw the writ application. But how a positive order can be passed without giving the other side an opportunity?
that in that order, my lord,
This is what order?
this is the in the pension and pensioner benefit has not been released since long.
Maybe in what circumstance pension was not released, pension was required to be released. Those aspects are required to be considered.
So in
And
2000,
if it have got during the pendency of the writ petition, and you are just struggling with this contempt proceeding.
so 2021 rules, 2024. Till now, they are
Very
already
difficult.
sending only that, but they have not been disbursed. And it is family pension.
Yes, Mr.
But since 20 papers were subject to the authorities. Because that compliance affidavit was also.
When did he file the pension papers?
Yes, sir. His papers were submitted in 22 only, my lords. He submitted the papers in March 2022.
March 2022, he submitted the papers.
And it was forwarded to the authorities with all the.
And you got an order in October 2021 that you should be entitled for 18%.
No, my lord, that the order is that you compare within a period of 2 months, my lord.
Mr. Counsel, when did you file your pension papers?
That part I will next week I will take instruction because order is
All right.
because
See, the order you got on 27/10/2020.
21, sir.
You filed the writ petition when? And this is the first order. 32,747 of 2021 is the writ petition. You must have filed it in October 2021. Your writ petition was disposed of on the very first day with a direction to release the pensionary benefits with 18% of interest.
No, sir. You release the pension within a period of 3% of the mailer.
We have read.
Spelling, sir.
Where is the question of filing which you had not submitted your pension papers? Where was the question of direction?
When I submitted my pension,
All right. If I find I'm adjourning the case for the next week. If I find that your pension papers were submitted after this 27/10/2021, then I shall initiate contempt proceeding against the petitioner for concealing this fact in the previous proceeding. This is not the way the cases are decided.
The pension with family pension, poor person is not getting the family pension.
So did you take the plea that you have not submitted your family pension papers? All right, I'm ready to hear. List this matter on. The petitioner has alleged disobedience of this court's order dated 27/10/2021, passed in WPC number 32747 of 2021, which was disposed of with following order, paragraph 2. So, next. The petitioner filed an affidavit as to whether he had submitted the papers for family pension papers before the competent authority, before the order dated 27/10/2021 was passed. So you will have to face consequences. Now. Yes, next.
Item 12.
What the complaints are being done?
In billing the fee to the.
No, please, the lordship.
Computer to the directly can write. The variables are.
Your lordship,
This model application was filed under the name of the times. The lordship, the office of the board is board is the lordship, there is an enforcement on the private road.
so what is the order?
The lordship, the order. The lordship, we have a release of annexure 1, page 5. On page 7, the lordship was directed to dispose of the.
All right. Disposal of the representation, first day, order disposed of. It took 1 second for you to get the order, and you are taking 15 minutes in the contempt proceeding for compliance of the order. Yes,
But it's NSC, we are not about, NSC officer has already not taken a decision, he has given a copy to us.
which order, which authority?
Yes, executive officer, national, notified area council, both gone.
Whether notice was issued. The petitioner has alleged disobedience of this court's order dated 1/11/2022, passed in
He has passed in regional order.
8301 of 2022. The said order was passed on the very first day when the contempt, when the writ petition was taken up. The order,
That was.
by the said order, the
अबे पटन
chief
लेफ्टिनेंट सब ओपी नंबर मतलब एनएससी में लग ऑलरेडी कंप्लीट दिया
chief
था
executive officer, Bodhgad NSC, was directed to consider the petitioner's representation. Petitioner's grievance. First off, the chief executive officer was not noticed in the
कंप्लेंट
said writ proceeding. First off, in such view of the matter, no case of deliberate disobedience of this court's order is made out by the opposite parties number 2 and 3. First off, it has however been informed that the petitioner's grievance has been considered and a reasoned order has been passed by the opposite party number 2. Stop the present contempt proceeding stands stopped accordingly.
Item 13.
अलर्ट माय अपीयरेंस विल ओपन माय
Yes, yes. Just want to state that.
Item 13. Item 13, my lord, also complied, my lord. And for the housing board, we have filed so cause, my lord, already.
Complied with.
Madam.
Stated by land council also. Who is for the petitioner? You are.
Petitioner, no, I am for the opposite party, my lord, housing board.
So there is no representation on behalf of the petitioners. Dropped.
Item 14.
Please close the similar. In this case, my lord, the writ appeal is pending.
Interview is pending. Yes.
Item 15.
SLP has been filed.
SLP already disposed upon 13/9/2024.
Which matter?
Item number 14.
14, you said.
They prepared the writ appeal before the lawsuit. That was dismissed on delay ground. Then they prepared the SLP.
Writ appeal pending. Yeah, SLP pending.
Now writ appeal is pending.
It has been remanded, so remanded and no content about.
Writ appeal is pending, your lordship may indicate that writ appeal is
on
pending.
demand from the Supreme Court. Dropped. No, dropped. Yes.
Item 15. May I please, my lord. Not complying, not serve me in the affidavit, my lord. This court directed to comply and file affidavit and serve copy of the council, my lord. Now they have not told that, they have not supplied any copy of.
Where is the order?
Order has been passed, my lord.
Where is the order which has been violated?
That is, my lord, in encroachment case, my lord, and government land has been, court has been passed order.
Where is the order of this court?
That is 30/11/2021, my lord.
Yes.
Yes, I have given a report to our assistant that pursuant to direction inquiry was made, 8 persons were found to be encroachers. Out of them, 2 persons who were landless, but they applied for settlement of the land, and in respect of them, the lease case is indicated. So far others are concerned, eviction proceeding is going on, where the law and order. So police help has been sought for, and we will complete the eviction. That is the
Order
instruction.
was passed on 30/11/2021. All right, file your so-called reply.
Yes, sir.
2 weeks. Time is allowed for the contenders to file so-called reply. Yes,
Item 16.
yes.
May I please, lordship? My lord, today I am appearing for the petition. In the meantime, previous council death, my lord.
Whether the order has been complied with.
It is, no, my lord, order not complied. Since order dated 20th/12/2022, my lord. Since that not complied with, the operating party is the consider the submission made by the respective parties. This court deems it proper to dispose of the writ petition at the stage of admission by set aside the interim order dated 30th.
Which order, which is
My
the?
lord, that is the page 13, my lord. Page 13. WBC number 34454 of 2022.
Mr. There was no opportunity given. This is again on the first day.
My lord, the issue involved in the Magananda Service case already decided by the Honorable Apex Court. Basing on that issue, Honorable Lawrence Singh judge set aside the.
But still, whether it is covered by Malayan city or not, that was to be very difficult.
Writ appeal is also pending.
Writ appeal is pending.
After 2 years, they have filed writ
Not 2
appeal.
years. How much time did it take for disposal of the writ petition? Tell me. When did you file your writ petition? Do you remember the date of filing of the writ petition and its disposal? Must be within a week.
My lord.
Very difficult. Yes. Drop.
Item 17. Yes, sir. SLP is pending. Bindu Sagar of that judgment, bro.
SLP.
Item 18.
Actually, it will comply with it.
Complied with.
Item number 19.
Item 19, order dated 11/3/2022 has not been complied with. The lordships that. I'm
Which
reading
order?
order dated 11/3/2022.
Where is the order?
That is under annexure 1 with page 13. And the operative is that paid 22, my lord. Thereafter, my lord, direction has been issued to grant the pay scale of principal at the rate of 9,350 to 14,000 and accordingly all the pension and other aspect.
Yes.
Yes, sir. It has been fixed as per the schedule, Lord. Now is the, by the time is has been fixed at rupees 24,650.
No, actual payment.
Actual payment, not so.
Actual payment, please ensure. Please ensure, otherwise I will take serious.
I will ensure that.
And then 5% interest also.
I have to do that, those in a minute.
Please do it, otherwise.
In the meantime, also confirmed by the Sumarlu, SLP has been already dismissed.
All right, therefore, the keeping your matter pending, so that the entire amount is paid to you. All right. Has been stated by Mr. L. Samantral and AGA that the amount which the petitioner is entitled to in terms of this court's order dated 11/3/2022 has been computed. 11/3/2022 passed in WPC OAC number 22201 of 2007 has been computed. And the same shall be paid to him soon. First off, list this matter on 4 weeks within first 10 cases. First off, in the meanwhile, if the court finds that the listed order of this court has not been fully complied with, the court shall initiate contempt proceeding against the contemptors. Yes.
Item number 20. Yes, item number 20 has been complied with. The amount that was directed to recover has been waived by the personal loss direction.
Yes, complied.
Nobody is there. No
one appears.
Item 21. Item 21, uncomplied manner. Complaint certificate not filed by.
Yes. Item
21 complied.
21 complied with.
22.
Complied with.
But there is a matter where by 2016,
22 next week, madam, I have got the instruct 22 next week, my file is misplaced, next week you'll also.
23 value this contempt is pending.
Which matter?
Next
22 has been called, sir.
But how is 22?
Since 23 is pending, I am praying for next week is up.
No. 22, you are appearing in 22.
Violent.
And how is that connected with 23?
Thus paying since 23.
Since
Since 23. Okay.
this is a third contempt and the case.
Third contempt, there cannot be third contempt.
My lord, we have.
There can be only one contempt.
My lord, we can't.
All right, you are not required. Yes, so next week,
My lord,
he does not have the file as requested on behalf of by AGA. List this matter on. Yes, next week. Yes.
Item 24.
24, madam.
23.
23 complied, madam.
24.
24. Read appeal is pending.
Writ appeal pending.
25.
25, SLP is pending.
SLP.
SLP copy.
26.
26 my lord, order not complied, my lord.
26 complied.
Copy.
Well, I'll serve the copy that I
Compliant with.
27.
27, 20, 29, SLP is pending.
SLP pending.
Item 30.
Item 30 will complied.
All right. Yes.
Item 31.
31 complied. I got the order also.
All right.
32.
32, my lord, SLP is pending.
SLP.
33. On behalf of Mr. Nayak, my lord, I am permitted to submit. This is a case of demarcation of land. And the Honorable Court on 4/5/2023 directed the Tahsildar to demarcate the land of the petitioner if there would be no civil court's order obstructing the demarcation. Thereafter, the Tahsildar gave us a date,
Where is the order?
that is page 9. You also kindly come to page 9, para 3.
Page 9.
Considering
You have quoted the order.
not quoted in page 9, that is, I have given the order.
Page 9.
Yes, my lord. Page 9 to the contempt petition.
There is no order.
Considering the innocuous request,
No order. Innocuous means what?
considering the
Innocuous means
innocuous
what?
request,
So it-
I am reading thereafter. This matter, you'll also kindly come to the ordering person. This matter stands disposed of observing, provided that there is no civil court's order obstructing the demarcation being undertaken. The demarcation request may be worked out.
Yes.
They gave a date, my lord, they gave a date for demarcation. Tahsildar gave a date. That is,
Tahsildar, your writ petition was disposed of on the very first day.
yes, my lord, you also kindly listen, my lord. After the order of the honorable court, Tahsildar gave us a date for demarcation of the land, giving notice to the boundary tenants. When we reach there,
You can challenge, mister. You pursue that matter, not here, not in the present proceeding.
when there was a order, my lord, that should be carried out.
All right.
In my soap, the
Petitioner has alleged
They are
disobedience.
giving the so-called reply, ma'am.
Without so-called reply, I'll decide it.
My lord, that is where, when there is a order, my lord, that should be complied with by the Tahsildar.
I understand that. That I understand.
They dropped the matter.
Yes.
Without complaint, they dropped the matter. When there was an order, my lord, from the honorable court, that is demarcated the land, they dropped the matter. That is total violation, my lord.
Should I start dictating order?
Yes.
The petitioner has alleged disobedience of this court's order dated 4/5/2023, passed in WPC number 11927 of 2023, which reads as under. First off, the said order was passed on the very first day when the writ application was pending. First off, the single judge has noted in the order that the petitioner's request was innocuous in nature. First off, counsel appearing on behalf of the petitioner has submitted that after this court's order, the Tahsildar had started the process of demarcation, but has not completed it. First off, in the court's opinion, considering the nature of the order, nature of the order passed by this court, violation of which has been alleged, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is thoroughly misconceived. A contempt petition is thoroughly misconceived and is accordingly dismissed. Yes.
34, my lord, complied.
No, my lord, 34 not complied, my lord.
Where is the order?
I have received the complaint copy, my lord, compliance affidavit.
Where is the order? Where is the order?
Order dated 6/1/2023, my lord.
Where is
And
that?
page number 7.
Page number 7.
Yes, ma'am. Para 4. And 5.
Make a detailed representation.
Yes, my lord, I have submitted. That is the page
Representation
9,
has
my
not
lord.
been disposed of.
Yes, it has not been disposed of, my lord. I am saying so, my lord. I have received the copy, my lord.
All right, all right.
They have taken the plea that in a similar matter, they prefer the writ appeal and they also went to honorable apex court, my lord. And in my affidavit now they are submitting, well, they are stating that the said SLP is pending, which is not in my case. but the said SLP is pending for which your dependation could not be considered. But in the meantime, my lord, the said SLP has been dismissed, my lord.
All right.
Yes.
The petitioner has alleged disobedience of court's order dated 6/1
On 9/7/24.
passed in WPC OA number 1281 of 2014, whereby the petitioner's representation was directed to be disposed of. First off, the petitioner's representation has been considered and the petitioner has been communicated that the said representation cannot be, that the petitioner's right claimed in the representation cannot be considered in the light of a writ appeal.
No, SLP.
SLP number pending before the Supreme Court. So stop. The petitioner accordingly, Land Counsel appearing on the behalf of the petitioner accordingly contains that the said communication does not amount to disposal of petitioner's representation. And therefore, case of deliberate disobedience of this court's order is made out. Stop. Next, the said submission is not at all tenable. Stop. The court order, the court had directed for consideration of the petitioner's representation and take a lawful decision thereon. Stop. In the opinion of the opposite parties, no final decision could be taken on the petitioner's representation because of the pendency of the SLP. Stop. In such view of the matter, in my opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding is dropped. Yes.
It will 35.
Given liberty, my lord.
The petitioner shall have the liberty to pursue his rightful claim before appropriate forum in accordance with law. Yes.
Although the benefit has been calculated, but the actual payment has not made, my lord.
Yes, what is the order?
84 years and
What is the order?
my lord, order dated 13 September 2022, my lord. Page 8,
Page?
8 to 16, my lord.
What is the operative portion?
Page 8 to 6.
Yes. Yes, Mr.
Yes, already payment has been. No, my lord, I have not received. I today morning, my lord, I have received.
It's a demand draft.
No, I have calculation.
Demand draft.
May I kindly supply one more copy?
Payment has been, what for? After having learned, heard Land Counsel appearing on behalf of the petitioner and done an AGA, it appears that this court's order dated 39/2022 has been complied with. Stop. The contempt proceeding stands stopped.
36. My lord, the petitioner is retired since 2021, but till today, he has not received any pensionary benefit nor the retirement dues.
Is that part of this?
Well,
Is that part of the direction?
No, another 36. No. Contempt item
All
number
right.
36 next time.
You have
Retired since 2021, my lord. He has
36.
not received any retirement dues. No pension.
What was the direction?
My lord, 7 into page 7 by 11.
What was the direction?
My lord, page 10, parad 6, my lord.
That is the whole difficulty.
Considering the submission, please. Thank you.
So have you considered the representation?
Yes, my lord, I have given that copy.
Item 35.
You have considered the representation.
36.
What have you decided? What is the,
My lord, till today he has not received any.
His area bills will be prepared in HRM portal, dispersed in due course. That was the order on 28/6/2024. It might have been paid. If the last will give me time next week, I take instruction.
next week? Please ensure that it is.
Yes, madam.
That will be paid by next. If not paid, that will be paid by next.
Requested on, I'm giving you 2 weeks.
Yes, ma'am. My file.
This is matter on 2 weeks. For an AGA to inform this court that the entire dues which the petitioner is entitled to has been paid consequent upon disposal of his representation in the light of this court's order dated 1/5/2023, passed in WPC number 13174 of 2023. Yes.
The lot 37. 37, 38, 39, all are compliant. I have given that.
Complied with.
Item 40.
My lord, I am on BC, my lord.
Yes, sir.
My lord, the order dated 31/10/2023
Yes.
in WPC number 34728 of 2023. My
Where
lord, order is attached, my lord.
Yes.
My lord, order is I'm sorry, my lord, para 4. In view of the apprehension expressed by the London Council appearing for the petitioners that the demolition is likely to take place today,
So this is an interim order.
my lord,
This is an interim order.
no, interim order. But my lord, they are going to demolish. We came to know that they are going to demolish today. That's why we came before the my lords in the it was taken up and mentioned.
This is an interim order passed
Order,
by.
my lord. What is the order, my lord? See, my lord.
Please wait.
My lord, defer the action. Defer the action of demolition, my lord. Defer the action of demolition till tomorrow. But they did not obey and they demolished, my lord. That was the case, my lord.
So now can you answer if I put a question?
My lord.
Whether the writ petition is pending?
No, my lord. Next day it was disposed of, my lord.
Next day it was disposed of.
My lord, it was the order was passed on 31/10/2023 and on 1/11 the order was the final it was disposed of. Because the demolition was going to take place, my lord. That's why this thing was done.
So what is the final order?
Final order was, my lord. My lord, I am just placing, my lord. The order number 1/11/23.
So you were the petitioner. You were the petitioner in that case, writ petition.
My lord.
So what was the final order?
Final order was Director having considered the submissions of the London Council for the respective parties in view of the order of this court in WPC number so and so dated 19th July 23 as at Annex 11, this court is to be considered view that relocation of Samadhi is to be considered by opposite party number 4.
No, this order must be there.
My lord?
This order must be that order. Where is the question of contempt? According to you, it was
before
demolished.
that they said, my lord, before that day, that is on 30/11. My lord, kindly see the
11.
order 31/10/2023, just prior date, my lord.
Yes.
When the case was put up.
Yes.
My lord said that state is requested to defer the action till tomorrow with
Yes.
an intimation to the authority concerned in this regard because they
Yes.
are coming to demolish the Samadhis. That is why they said that tomorrow it will be taken up, but there should be no demolition.
But tomorrow what happened?
My lord, tomorrow that
Tomorrow,
order.
did you inform the court? Did you inform the court that it has been demolished?
Yes, my lord. That was in para 3. Para 3, London Council will petition submit that Samadhi.
So what was the opinion? What was the opinion on that of the learned single judge?
My lord said that the petition has been over the government land for a long, and insofar as the interim order dated 31 October 2023 is concerned, it has been violated, followed by demolition of the structures standing over the same. In response to the above, my lord, so and so, my lord. The court agreed.
Where is that order?
My lord agreed.
Where is that order?
My lord, the order dated 1/11/23.
Where is that order?
That is in the writ petition, my lord,
All right.
I have not, my lord, writ petition.
So you should have
4728 of 23. My lord?
All right, let me see.
Order dated 1/11/2023.
Just a minute, Mr. Just a minute.
My lord.
No contempt is allowed.
My lord, may kindly see this my lord, the my lord directed earlier that to file an affidavit, and we filed the affidavit, my lord, affidavit.
No, Mr. A stand was taken that before the order was passed, the demolition had already taken place.
Yes, that's right. But before that, that's for the matter. No action to be taken, my lord. This is the order. The order under my lord impugned in the contempt petition is the my lord directed not to take any action.
All right.
My lord may see the previous order that just previous
Mr.
order 31/10.
Mr. Rota, please come to paragraph 3 of the order. Dated 1/11. Mr. Mishra.
1/11 order, my lord. My lord, that is true, my lord. After this demolition, only this thing happened, my lord. My lord, this was deferred. This demolition to be
All right.
deferred.
All right, I'm not inclined.
Item 41.
My lord.
Yes.
SLP is filed.
SLP.
42.
Not complied, my lord. That is complied order.
What was the order?
No, my lord, no complaint, because
What was the order?
16 and 17,
The order.
their order is for eviction, my lord.
There was direction for eviction.
Yes, my lord. It is place 17, my
I
lord.
have not seen any such order passed by this court. Let me see.
Yes, my lord, it is place 17, my lord.
Just a minute, where is the order?
To ensure the removal of any encroachment from the government as soon as possible and complete the entire exercise literally within the period of 8 weeks.
Where is the order?
My lord, place 7, date of adherence 14/9/2023.
Is the order?
Place 16 and 17. 17 is the last paragraph.
Same thing. To examine Article 3,
Yes, my lord. To ensure
provide an opportunity of hearing, as well as arrest encroachers. 8 to 9, pass necessary orders required.
to ensure
Removal.
to
So
ensure
take the direction for,
yes, my lord, to ensure the removal of encroachment, my lord.
yes, and if required,
Yes, my lord.
the
And now, my lord, what happened there?
at least disobedience of sports order dated 14/9/2023, passed in WPC number 29221 of 2023 on the very first day when the writ petition was,
The last proposal, BMC was directed, my lord.
there were two private opposite parties in the said writ petition. First off, they were also not only
My
noted,
lord, last proposal, BMC was directed, my lord.
the
To
petitioner,
the glance, my lord. To last
The
order related.
petitioner, the following is the operative portion of the said order, paragraph 7. First off, what is your stand?
Now, BD has already, chairman has taken decision and directed the BMC to take up the appropriate action with regard to enforcement.
Which chairman?
My lord, BD, I'm applying for BD, my lord.
BDA.
My lord, Municipal Development Authority, my lord.
It is stated on behalf of the BDA that steps are being taken for removal of encroachment from the government plot in question. So next, in view of the nature of order which has been passed, violation of which has been alleged in the present contempt application, I am of the view that no case of deliberate disobedience of this court's order can be said to be made out on the ground that the encroachments have not been removed. So the contempt proceeding is dropped.
Item 43. My lord, for the last to be ordered dated 5/2024, this only code narrated to the DMC DMC also directed, my lord.
Counsel appearing on behalf of the petitioner. Give the order.
DMC also directed.
Learned counsel appearing on behalf of the petitioner has drawn my attention to an order dated 5/1/2024, passed in CONTC number 8930 of 2023. In the present contempt proceeding, whereby the paragraph 4 of which reads thus: in no case in the court's opinion, in a case of deliberate disobedience of this court's order is made out, requiring this contempt proceeding keep pending. The contempt proceeding is dropped.
Item 43. Speaking of a passing.
Your lordships kindly have it. Here is the order dated page 12. Page 12. Order was passed taking into account the way number 98 of 16. The government has page 12 passed. Now I have already handed over. No, but they have not taken into account that what are the
Let me see where is the order.
Yes, page 12. Having heard the law and counsel for the parties and in view of the fact that similar order passed by the Land Tribunal has been implemented in the meantime, this court, while passing the order, that there is a rejection order. Direct the opinion number 1 to take a fresh decision on the claim of the petitioner in the light of the order passed in 19 of 16. 19 of 16 of the order has been implemented.
Yes, you can challenge that. You can challenge.
But they have in the rejection order, they have not taken into account that
The
decision.
petitioner has alleged disobedience of this court's order dated 21/10/2022, passed in WPC OSC number 296 of 2018, operative portion of which reads as under paragraph 6. It is not in dispute that a fresh decision has been taken by whom?
Opinion number 1, the government, madam.
By
Opinion number 1.
the OP number 1.
Secretary Student Master.
OP number 1 dealing with the petitioner's claim. Learned counsel appearing on behalf of the petitioner has submitted that the said decision cannot be said to be in conformity with the order dated 21/10/2022, as the contemners were required to take a decision in the light of the order passed in OA number 98 of 2016.
98 of 2020. 16, madam.
I am not inclined to consider such aspect in the present contempt in the present contempt matter, as the action of the contemners cannot be said to be amounting to deliberate disobedience of this court's order. In compliance of the order of this court, the opposite party number 1 has taken a decision. Thus, which indicates that he had intentions to comply with the court's order. If according to the petitioner, the decision taken by opposite party number 1 is illegal, he shall have liberty to question the same before appropriate forum in accordance with law.
44. 44, my lord, speaking of order also passed.
44 is same.
Same, my lord. 45. What is the writ appeal number? Writ appeal is pending, my lord. Now, in the writ appeal, they have paid for the control security in the paragraph 6. The government has submitted that they will file further affidavit of control security. Accordingly, yes, so
When the writ appeal is pending, where is the question? Writ appeal you make up.
they have paid for the according paragraph 6 of their counter. That in the state appeal before survey record, this depends based on the case. Before survey record to allow time to dispose of the rejection to bring the issue of a medical aid and to file appropriate complaints affidavit before the survey record. So
There is no question of time. There is of intention to not to comply with the order. So if the intention is not to comply, we are there to punish them. But if they did not accept the order, they challenge that. It was not their intention to violate.
And in this case, I will need to add my love. They have paid for time. So that should be allowed.
All right. What now?
Yes. And in this case, I am appealing for private application number 3. Our appearance member could
Drop. Yes. Give us.
Item 46.
46, my love, SLP is pending, my.
Pending, yes.
SLP.
Yes, SLP is pending.
Yes.
Item 47.
47 grants some time, my.
My liberty may be given. Liberty may be given.
When the SLP is pending, then what liberty? That is always there.
47.
47 you are seeking time.
My love, grants
From the first time, the order has not been complied with in his case.
my love, kindly grants.
Yes, as requested on by HEL, is this matter on 1 week?
My love,
1 week. Yes.
So 48.
but trade my love complied with.
It may let they file the reply. I will go through this and let it come after vacation.
See the order.
Complied with me.
Interim order may let the main writ is pending.
Alright.
After serving for 12 years, they have suddenly without any notice, they have retrenched the services and your lordship passed the interim order that as an interim, the director no event the no regular equipment has been made in the meantime, then the petitioner shall be engaged till regular equipment is made. Until then, the petitioner has not been restored to service after serving for 13 years. Now she is
The present contempt, in the present contempt application, the petitioner has alleged disobedience of an interim order passed by this court in court dated 13/6/2023, passed in WPC number 16931 of 2023. Where is the order?
order that page number 8, my love, of the content petition. Page number 9.
Where is the order?
My lord, that is my lord. Page number 8 of the content petition. And
Where is the order, interim order?
interim order, my lord, that page number 8 of the content petition starts on 13/6/2023. The next page is the direction portion, page number 9.
Where is that?
My lord, I have enclosed to the content.
Page number 9 is not there.
9. Sorry, my lord, I have that copy.
And the writ petition is pending.
Writ petition is pending.
This is in fact, my lord, he was working under the outsourcing agency. And that outsourcing agency, after completion, was withdrawn. And he has filed this petition, and by on 13/6, he got an interim order. And prior to that, my lord, another agency was appointed and one person also engaged.
Well, all the staffs are continuing the same steps of the previous outsourcing agency. And after serving for 13 years, my lord, in the entire district, in all blocks, the staffs are continuing except me. Well, the new agency is to allow that and for continue.
go and deal with the agency, not with the.
My lord, since that is a regular vacancy, that is why the order was passed, my lord, in spite of they have engaged another new person. And I am out of employment after serving for 13 years, my lord. And now, my lord, I have become over age bad and ineligible to apply to any other post, my lord.
So you should be given what post? Registrar? of the
My lord,
court.
the same, my lord, since all of my batchmates are still continuing. So
Where are they continuing?
in the different block, in the district, my lord,
Where?
in the district of Raigad,
Who has engaged them?
my lord, as per the previous agency, they are continuing.
Agency has engaged them.
My lord, the government post, the government has responded to the agency and the government has allowed them to continue. And the government has retrenched me, my lord. Not the, as per the instruction of the video, I have been terminated, I have been retrenched.
Which reads thus. First off, the petitioner was engaged. And, by an agency
Against
on
the regular
on
sanction.
posting basis. Stop. In the facts and circumstances, in the court's opinion, no case of deliberate disobedience of this court's order is let out. Stop. Contempt proceeding is dropped accordingly.
49.
Is also complied with. Complied, but year of the mutation case number is different matter, and that has been written at 2023 instead of 2009. Typographical error.
All right, that will get corrected there.
Ma'am.
Yes.
Item 50. My lord.
My lord, the is pending, my lord.
Your lordship, one thing, my lord, your lordship, this is the third contempt, my lord. After dismissal of the review and in third contempt, your lordship kindly see the order dated 1st March 2024. Basing upon their letter issued by the opposite partner 3 to opposite partner 1. Kindly see the.
See, third contempt.
In third contempt after dismissal of the also review. They now they filed the review, against the review. After the dismissal of the review, second contempt of disposal and third contempt, your lordship directed this honorable court direct. Can you see the order dated?
See, this first contempt, second contempt, third contempt, these things do not persuade me for initiation of contempt proceeding. Contempt proceeding can be one. The second contempt proceeding can be for a second order. It cannot be for the same order.
First order, they are not complied with the.
First order,
For a moment, you can see the order dated 1/2/24.
surely I'll see. Yes.
For this order,
Where is the original order of this court?
original order, your lordship can see page 13, 13 and 14,
Page 13.
13 and 14. Paragraph 3.
Yes.
This court in case of Dilip Kumar Sahu and others versus State Police and others, 2008, 1 OLR 162, while dealing with the similar situation, directed that the petitioner who have worked out.
Yes. So before passing of this order 27/8/2015, notices were issued.
Yes, the order was passed in 2015. A batch of order, writ application filed before the lordship.
I'm again putting the same question. This order was passed on 27/8/2015.
Yes.
Whether before passing of this order, notices were issued.
No, well.
After this order, they are not complied with. For that reason,
Again, I am putting the same question. Whether before passing of this order, the opposite parties were given an opportunity to file affidavit.
no, my lord.
No. All right. that counsel appearing on behalf of the petitioner states that this court's order dated 27/8/2015 has been violated. Stop. Next, Learned AGA has informed this court that writ appeal against the order dated 27/8/2015 is pending, registered as WA number
12936 ma'am.
1/2024 6 of 2024.
24 ma'am.
Stop.
No,
The
12,000 not so.
order,
No, my lord,
just a minute.
Since
The order violation of which has been raised in the prison contempt application is of 2015. And a writ appeal is pending. Sealing the said order, let the records be placed before the Chief Justice for fixing an early date of
filing number.
hearing
Filing number.
of WA number.
my lord, the writ appeal arises out of a review order. Out of a review order. Review arises out of the writ appeal, my writ application. The writ application order against review order against review.
Please appreciate this, that I was also member of the bar. I have
Yes.
some experience,
You'll also
as much as you have, but I have some experience of that side and this side also.
yes.
So I understand that writ appeal must have been filed against the order passed in review application.
Yes.
See, I'll see.
They have elected one and one contempt order.
We are not arguing in the writ appeal. I'll consider that. You want writ appeal to be decided. That will be decided.
No, that's true, my lord, also beside the writ appeal, because what they have harassed the petitioner from 2015, just till now.
Who has been harassed, we don't know.
In the meantime,
Who has been harassed, Mr. Counsel, we don't know. This order, see, every party has to be treated equally.
my
Whether
lord,
it is state or a private respondent for the purpose of adjudication. So when this order was passed without giving an opportunity to the other side to take its stand, who was harassed?
April also permitted, I guess, small.
We will see us.
And
We will see that.
SLP also dismissed, my lord,
Not now,
in similar cases.
not now.
51.
Right, please, your lordship. The order dated 4/5/2023 at annexure 1, page 4 of order dated 4/5/2023 at annexure 1, page 4 is the non-compliance of which against which I filed this contempt.
Where is that order?
My lord, at page 4. The operative portion is at page 5. The opposite party was directed to conclude the certificate case in the OPDR proceedings within a period of 6 months. But despite that, now even more than 1 year and 3 months have passed till date, he is not moving.
See, if this is accepted, then contempt proceedings can be initiated against us also, against your Chief Justice, on the same ground which you have taken in the present contempt.
This I was compelled to file because the Honorable Supreme Court has directed that execution case should be inordinately completed within 6 months.
Yes,
So here,
it's very difficult.
the opposite party, your lordship will see, he is only issuing notice. In this case, my lord, certificate case was initiated, my lord, and the notice was also issued, my lord, and the investigation sessions. My lord, I will take instruction whether that is
Try
decided.
to conclude, it is not that preferably the petitioner has alleged in disobedience of this court's order dated 4/5/2023, passed in WPC number 13937 of 2023, whereby this court disposed of the petitioner's representation, directing the additional district magistrate from certificate officer to expedite the certificate proceeding, concerned certificate proceeding, and try to conclude the same expeditiously, preferably within a period of 6 months from the date of communication of the order. First off, in the court's opinion, in the light of the nature of the order passed by this court, no case of deliberate disobedience of this court's order is made out on the ground that the said certificate proceeding could not be concluded within a period of 6 months. First off, it is not the case of the petitioner that the certificate officer has not proceeded with the said certificate case, proceeded further in the said certificate case. The contempt proceeding is dropped accordingly.
My lord, only my submission, he has only issued notice and he is adjourning the matter without attaching the bank account of the judgment debtor. He should have done it.
52. Deputy Mayor, we have filed a Retiral bill number 660/24, my lord.
Ready to appeal.
Item 53. 53, my lord, your lordships. Your lordships, last occasion there is a honorable court directed to submitting the compliance affidavit with certified copy. Your lordships.
Where is the order?
Order is lordships. Running page 17 of order dated 24/8/2023, passed in WPC number 25,620. Your lordship, running page 17 years.
There is no order. Again, first day. Sorry.
Your lordship, back to pardon, there last occasion honorable court directed her to file the directed to the land council of opposite party contempt to file a compliance affidavit with certified copy of the mutation case number 26/2022. This is honorable court last
The order in the main case.
running case order in running 17 years.
Huh?
Running case order in running case 17 in contempt petition. Running case 17 years.
17, main case is page number 6. You are alleging
My lord, he is in supplementary list. Supplementary list. He is in supplementary list. I beg to pardon, sir. He is not page 17. I beg to pardon, sir.
There is no representation on behalf of the petitioner. An order dated 16/8/2023 passed in WPC number 25729 of 2023 is said to have been violated by the contenders. First off, the said order dated 16/8/2023 was passed without passed on the very first day when the writ application was taken up. First off, the said order is conditional in nature to the effect that the Tahsildar was required to pass an order if he was in receipt of an application as contained in Annexure 4. First off, in such view of the matter, no case of deliberate disobedience of this court's order is made out. This contempt petition is dismissed. Yes.
54. 54, my lord, the compliance of by this state. But my humble submission before lord.
Where is the order?
Order is, your lordship, sir. I'm speaking order passed, I have already handed over.
Speaking
At
order
page
has
12.
passed.
stated that it is not consonance with the order passed by this honorable.
Challenge that.
Yes, Your Lordship. Your Lordship will give liberty to the petitioner to challenge.
55,
Liberty may be granted.
Liberty.
56,
Item 50. There is a SLP pending, Malaj. It's coming up the next week. If your lordships can adjourn it.
You can come after the file first contempt application.
It's coming up next week.
Prompt.
57,
Petitioner will comply with. Speaking order passed.
58,
50 Lordship prefer next week, Lordship.
Comply with.
Lordship. Apply next week, Lordship.
Why? Why? What is it? Yes, 50, 50.
58,
58.
Yes, where is the order? Representation, yes,
Madam, I'll take instruction, but I have not received.
next week.
59,
59 Malad complied with.
Complied with.
60. 69 we have filed SLP Malad.
Malad, writ appeal also dismissed it. And this is a matter relating to sanction of a provisional pension.
Writ appeal dismissed on what ground?
Writ appeal dismissed on the ground 267 days delay.
Okay, wait for this. Dismissed, dropped.
61.
Order dated 16/10/2023 has not been complied. This is regarding the shifting of a transformer from my land.
Just a minute. What is the order?
Will I read the order, my lord?
Yes, where is that?
Order dated 16/10/2023.
Where is that order?
Order I have quoted in page 3, my lord. Page 3 of the contempt application.
Yes.
Order dated 16/10/2023. This matter is taken up through hybrid mode. Petitioner in this writ petition seeks for a direction for shifting of a transformer installed on his recorded land in plot number so and
There
so.
is no direction.
My lord,
There is no direction just for consideration of your report.
no, I have, my lord, the order was to file a grievance petition before the collector. And I have filed a grievance petition before the collector, which has not been taken yet,
Which has not been?
which has not been considered yet.
Yes.
On 16/10, this order was passed. On 26/10, I have preferred to give a petition before the collector of Ganjan.
Yes, whether you have
See the instruction.
all right, 2 weeks
Next week.
62.
as requested.
Next
Thank
week.
you, Lord.
2 weeks.
I'm in virtual mode, my lord.
Receive
I
62.
may be excused. Item 62. So, a statutory appeal for renewal of my Khasmal lease in the Cuttack Town property. We are in possession since 1975, but the property could not be renewed despite the statutory amendment.
Where is the order? Where is the order? Where is the order of this court?
Page 8, your lordship.
Mr. Counsel, where is the order of this court which has been violated?
Page 8, your lordship, kindly page 8. Am I not audible, my lord? Page 8.
Yes, page 8.
Yeah, there are two points, my lord. First you entertain, then you dispose of. Till date, they have not even entertained.
Just a minute. Yes. What is your instruction?
I have not received the instruction. Next week, let it come. Next week.
No, 62, है ना?
62. 62, man.
62.
Yes, ma'am.
Two weeks time is allowed for the Poland AG to seek instructions. To the limited extent as to whether the What is the order?
Order is to entertain my application for renewal, which is a statutory application, my lord. Under the OGS Act,
Original order of annexed 3 is extended to Tahsildar. What is the meaning of extended?
my application, my lord, that to be entertained, my lord.
Extended means what?
What I understand, my lord, that is for to entertain my application, and that extend, if I extend it, it
Not
will also go in the that application I had annexed there in the writ petition, that is Annex 3. What I understood, my lord, Honorable Single Judge directed to take up my application if I
Instruction as to whether this court's order dated 5/7/2023 has been complied with or not.
apply. Okay. Good.
Expiration within a period of 6 months.
So your appeal has been registered.
There is a direction to register the appeal, but the till that the alleged complaint not intimated any report to the petitioner lordship.
So they were required to intimate that now your mutation appeal has been registered.
But they have to decide the mutation appeal. Their appeal is direction.
Whether the mutation appeal has been registered or not.
That's it. But this is, the instruction is not. The same instruction is not available.
Whether it has been registered or not.
No instruction. Lordship.
No
Instruction
instruction.
of the mutation appeal.
Then there is nothing. The following is the operative portion of the order dated 13/6/2023 passed in WPC number 18637 of 2023. A violation of which has been alleged in the present contempt application. Paragraph 5. Learned counsel appearing on behalf of the petitioner does not have any instruction as to whether the mutation appeal has been registered or not. Stop. That was the only positive direction given by this court by the said order dated 13/6/2023. Stop. The further direction was to the effect that the appellate authority shall try to dispose of the same within 6 months from the date of registration. Stop. I do not find any direction issued by this court which can be said to have been deliberately violated. Stop. I do not find any merit in the present contempt application, which is dismissed. Yes.
Also having liberty to
No liberty.
I might be required
In such matters.
64. 64, my lord, complied. Speaking order.
My lord, the order which was passed by your lordship was a vetoed violation within time stipulated, no compliance has been made, my lord. Because annexer, please make a class with the annexer 1, please. Please make a class with the annexer 1. Running, that is order dated by your lordships. That is order
Sir,
dated.
again, this order was passed on the very first day. What was the order?
The order was to provide promotion for the post of the deputy review engineer under the Puri municipality, Puri, my lord. Had annex 1 running.
Sir, this is 785 of 2024.
Order dated 4th of October 2023. Annex 1.
Contempt is 785 of 2024.
The first contempt order, before your lordships, my lord.
I will not see any first contempt or second contempt order.
So far,
This is the order.
yes, yes.
No other order can be said
My
to
lord,
be.
24th November 2023.
Well, whether your representation has been disposed of or not.
Now the copy has been served to me.
All right.
I've filed a compliance affidavit
You can challenge that order.
Yes.
Where is the question of violation?
The violation because so far annex or
Mr. Counsel, your direction was for disposal of your representation. Your representation has been disposed of. That's all. You can challenge that.
with liberty, madam.
Liberty. Liberty.
65.
55 also complied.
The letter of complaints may kindly given to me because yesterday night only the petitioner informed that no steps have been taken by the authority.
What is the order? Let me see.
Order number-
He is in the supplementary list, right? Supplementary.
Yes,
Weekly.
sorry.
Weekly is complied. I have some copy of the.
Compliant liberty.
66.
2023. Non-compliance of the order dated 7/8/2023 only. Non-compliance of the order dated 7/8/2023 only. Page number 11.
What is the order?
Page number 11 only. And in this case, only the content we have already filed their status.
We have filed SOTOs. Here in the EC case, the report was called for, report has been received in the meanwhile. And they have sought for certain documents from the concerned person that it will be complied, if the lordship may grant us some 3 weeks time, we have filed a SOTO.
This is 859.
Yes, madam.
My lord, 859.
Come to the order. I have 8.
Yes, madam. That has not been complied, madam. According to the content of already filed status, and taking adjournment for 3.
Such orders can never be complied with. It is impossible.
And in this case, madam, some unauthorized construction has been made.
Unauthorized construction, just see the order, read the order. And if this is the order there with you to comply with, can you do it? Consider the application of the petitioner possibly treating the same as so cause in the proceeding so and so and pass a final order. And complete exercise after providing due opportunity of hearing to the petitioner and other effective parties within a stipulated period. 4 weeks. How can this be done? 4 weeks from the date of. And this order has been passed on the very first day. Yes, what is your instruction?
Your lordship, we have filed a SOCOS affidavit. In the EC case, after the notice was issued, the other party has filed a writ petition. And also that writ petition was treated as a SOCOS in the EC case. And thereafter, there is a progress and we have filed a SOCOS affidavit. If your lordship may kindly see.
The petitioner has alleged disobedience of an order of this court dated 7/8/2023, passed in WPC number 24529 of 2023. Comma, on the very first day when the writ application was taken up with the following observation and direction, paragraph 8. So stop. The said writ petition, opposite party number, said writ petition 1, Pradeep Kumar Sahu, was impleaded as opposite party number 1, who was not noticed. So stop. Said Pradeep Kumar Sahu also filed a writ petition before this court, which gave rise to what is his number?
WPC number 10748 of 2023.
WPC number
0748
10748 of 2023.
2023.
He had filed before you had filed.
Yes, ma'am. Thereafter the because some sections are unauthorized construction.
Right, so he had also,
Yes, ma'am.
so his writ application has also been disposed of. Stop. And AGA, referring to the averments made in the so-called notice, so-called affidavit, has submitted that the EC case number 15 of 2023 is progressing. So, considering the nature of the order passed by this court, violation of which has been alleged in the present contempt application, no case of deliberate disobedience is made out. So, contempt hearing is adopted.
67,
Same man, 67, 67 man.
Same order.
68.
Same man.
Pradeep Kumar Sahu.
Yes, ma'am.
Pradeep Kumar Sahu was
In three application is the opposite party number 4, ma'am.
OP number 4 filed this contempt application for implementation of the order passed in case of the petitioner. Your Lordship may kindly see the cause title in the item 66. The cause title, the writ petition was filed by Notavaro Swine. And the name of the petitioner in the contempt petition is Pradeep Kumar Sahu.
I have mentioned the contempt petition that opposite party number 4 oblique petitioner, ma'am. In the contempt petition, ma'am. In the writ petition order, you can see the page number 4, ma'am.
Okay, I will dismiss this contempt petition with cost. So this is intolerable.
You can see the page number 9 in opposite party number 4, ma'am.
I will dismiss with this contempt petition with cost. I'll have to change the order. I was under the impression that this contempt application has been filed by the petitioner of the writ petition. कौन सा है item number 66?
Item 66.
Order को काट दो.
Annexure 1 is the order. The cause title, your Lordship may kindly see in the order sheet.
The
That is by Notavaro Swine.
petitioner in the present contempt application was impleaded as opposite party number 4
Yes.
in WPC number 24529 of 2023, which was filed by the opposite party number Sumant Senapati, who is Senapati, who has not been impleaded as party in the present contempt application. Stop. From the order passed by this court, it appears that the dispute related to a removal of encroachment in the light of certain order passed by this court in WPC number 10748 of 2023. Stop. The in the light of the said order passed in WPC number 10748 of 2023, an encroachment proceeding was initiated against Sumant Senapati, which became subject matter, which was challenged by him in WPC number 24529 of 2023, which came to be disposed of by an order dated 7/8/2023, operative portion of which reads thus. First off, the it is apparent from this court's order that there was no specific direction for disposal of the encroachment case within a particular time. First off, in any view of the matter, the said order was encroachment case. First off, the petitioner was opposite party number 4 in the said writ application has filed the present contempt application alleging disobedience of the order dated 7/8/2023. First off, in the court's opinion, in the facts and circumstances noted above, the petitioner has misused the process of court by filing present contempt application. Accordingly, the contempt application is dismissed with a cost of ₹5,000 to be deposited by the petitioner in the account of advocates will fund tribunal. Yes, next.
I am the I have filed the writ application since the opposite other parties are controlled the provisional and the construction for the dispute devices. And sitting over the matter is flat 1 year number. I am the application
67.
but one that cost may be additional.
Next, 5,000.
So, where the cost may be about. Pardon,
5,000.
cost may be about.
67 and
I am operating settlement number 4 में I filed it. But the cost may be about.
3 contempt applications were filed.
67, 68 also same. What you may kindly see the cost title of the
68.
order.
You I maybe change the orders like
Petition 24536
Still remain.
Bharati Jana.
Cost may be about.
item 69. Complied not, press Miller. Not press Miller. 69. Item 70.
70, my lord, writ appeal pending. Writ appeal number 1.
But let's kindly see, here let's kindly see the judgment that is by order 17/5/2023. And let's you have considered my earlier contempt petition, let's kindly.
Rate appeal is pending.
Let's kindly come to page 34. There is a statement prior to earlier contempt petition, let's come to page 34.
Item 70.
70.
Just a minute.
70, that page let's can come to page 34. Because the order dated 17/5/2023 is under because let's can reaching order.
Just a minute.
Let's see.
You are alleging disobedience of this order.
Let's see.
22/12/2023.
23.
Rate appeal is pending.
Let's see.
What is the number?
Let's see. Writ appeal, sorry. Let's see. Writ appeal.
Yes.
Writ appeal number, let's see that 555/24. They're saying, let's see.
No. It is stated by
13027.
and counsel appealing on behalf of the
13.
No, which order is under challenge?
Lordship, on 17/5/2023, Lordship.
Just a minute. Where is the order?
Starts from Lordship, running page 13 of the brief, Lordship. And Lordship, operative part, Lordship, at running page 33 Lordship, 29, Lordship.
So they have filed appeal.
Lordship, information kindly come to page 34.
Yes.
Lordship, earlier on 22, 12 and 23, there is another content petition, Lordship. And while considering a statement, there is no writ appeal or anything pending before the Honorable Court, the Lordship dispatched my content petition to consider my case. And Lordship,
They have filed a appeal.
Lordship, it cannot be my humble submission. It cannot be continuous process where filing a writ appeal and Lordship can listen when done the writ appeal. See, last 6 months, 7 months, it is yet to be listed, Lordship. So mere filing a writ appeal cannot, Lordship, become a right.
They cannot list the writ appeal.
Lordship, they're not making any.
They cannot list the writ appeal. They cannot be blamed.
But they're making mention of the Lordship. Also, kindly see in the other cases, we are making mention and saying the state to.
All right.
They're not making any effort, Lordship.
A writ appeal is said to have been filed against the court's order dated 17/5/2023, passed in WPC number 765 of 2000.
2016, Lordship, my writ petition.
2016. Full stop. The white WPA number and WA number.
But the writ appeal number,
Ah.
WA number 13027 of 2024.
The petitioner is alleging disobedience of this court's order. In the present contempt application. Please complete, let me complete the order.
Lordship.
Please don't interject.
No, but Lordship, you give me a wrong name.
Don't interject when I dictate the order.
Sorry, extremely sorry.
Please. This is my earnest request to the members of the bar. Please don't interject when I dictate the order.
Lordship.
This court's order in the present contempt application, which is under challenge in the said writ appeal. The top. That the reports of the writ appeal numbers will also be placed before the Chief Justice to consider fixing an early date of hearing. Yes.
May Lordship make one, the number is wrong, Lordship. The 555 is given a diary number. So that's why I'm making mention.
But this status I have opted.
Yeah, number 555.
Yes.
71.
Yes.
71. I have received Stoker's instruction. What's in my grant me a week's time, I'll file this.
Which item?
71.
71.
71, yes. Writ appeal.
No, but at 71, a week's time may be granted because I have received the Stoker's instruction, I'll file.
1 week has requested on behalf of the CGA. Yes.
72.
72, my lord, SLP pending. SLP 35516 of 2024.
SLP.
73.
73 also same. SLP pending.
Yes.
74.
Yes. Someone is appearing.
74, in the meantime, the encroachment eviction proceeding has been completed. That is the instruction I have received.
Someone appears on behalf of the petitioner to press this application. When counsel and AGA has stated that what is the proceeding?
But, Lot they have indicated the proceeding number. My lord, encroachment case number 4 of 96/2021.
No, but it was also for disposal of representation. Is this the 133 of 2024?
My lord. 1338 of 24.
Contempt proceeding with this first.
75,
One of you, this first. Yes. Compare.
76,
76, my lord, also complied. Serving a copy of the
Compare with liberty.
item 77,
Milord, valid order dated 4/10/2023, passed in WPC number 31049 of 2023, the opposite party number 3 was directed to consider the grievance of the petitioner within 3 months and communicate the result of the same. As he has not complied with the order, the petition has to file
Company
593.
has not received the instruction, will also make keep it to
You
next week.
receive.
And valid order dated 1/3/2024, it was directed to consider the same within 1 month. Milord.
Next week, and
This is the second contract, madam.
Read the whole order.
Milord, the third one, 4/10/2023, Milord.
Which is the order which has been violated?
Milord, page 10, Milord. Para 5,
Page 10.
page 10, para 5. Considering the submissions made and without expressing any opinion on the merits of the case,
Just a minute.
Milord.
You are not annexed.
Milord, I have annexed.
Where is
Order dated 4/10/2023, Milord.
it? Which contempt application? 1433.
supplementary.
Is appearing in some other case.
He is in some other place.
You are appearing in 1433.
अपना contempt number कितना?
What is the number?
It's supplementary list, Milord.
Hold it.
Content number 4269, Milord.
No. Not the correct case.
77,
WPC is pending. Does this matter? This case along with WPC is still pending. Huh?
Let us tag with this. Dispose of case for modification IA.
The WPC 12382.
Dispose of this.
That's also. Considering the nature of this, after having seen this court's order dated 21/4/2023, passed in WPC number 12382 of 2023. In my opinion, no case of willful disobedience of this court's order is made out. The contempt proceeding is dropped.
78,
78, my lord, SLP pending.
79,
29, yes,
My lord, senior is appearing on GC, my lord.
79.
Yes, ma'am.
So what should we do?
79,
Where is the pairing? What do you want? Is he online? Appearing online?
Yes, my lord.
Where is the order?
Yes, file this contempt for violation of the interim order, my lord. Interim order of status quo passed by this honorable court,
The matter is pending.
my lord. Matter is pending. And after the status quo order was obtained, received by the authorities, they have recalled the registration of the cell deed. They have kept it in abeyance, and the mutation case also,
All right.
that order has been
Let's
recalled.
this contempt application along with WPC number 14862 of 2023, which is pending
Item 80.
before application bench.
Here, petitioner has been selected as a junior stenographer, Myla, and as per I have quoted the order. I have a glance. Your lordship has a glance at page 5, Myla. Last para, she should be included in GPF scheme and benefit under OCS pension rule 1992. The direct order is 92, but she has been included in GPF scheme, my lord. OCS pension rule 2005, my lord.
So when was this order passed?
Order has been passed on 3/4/17
You filed this contempt application in 2000.
No, my lord. Thereafter, my contempt petition has been filed at contempt CP number 339/2017 at para 3 page 6, my lord. That has been after report of SAT, my lord. The State Administrative Tribunal has been deported. Thereafter, that has been listed at this honorable court, my lord, as a CP number 339/17, my lord. That is, I have annexed, my lord, at annexed to 2 page 17, my lord. And the order has been passed on 10/1/22, my lord. They have specific directed to include her in 1992 OCS pension scheme rule, my lord. Thereafter, they have not complied, my lord.
Oh, yes.
Your lordship may kindly see annexure 1. Annexure 1 is the order passed by the tribunal. 3 original applications were disposed of, including the petitioner. But the 2 other petitioners in original application 1987 and 1990, they filed separate writ petitions before this honorable court, seeking implementation of the order. However, the direction was passed to consider their representation. Now, considering those representations, their cases were rejected. So also in case of petitioner, they have passed this order of rejection, my lord. That is the.
I have not gone through the.
See, you can challenge.
My lord, it may be taken next week, my lord.
Why next week?
Next week.
All right, as requested on behalf of it is the stand taken on behalf of the contenders that nothing remains to be complied with as regards the order passed by the Orissa Administrative Tribunal dated 3/4/2017 as an order has been passed on which day?
26/2024.
26/2024. A copy of which has been made available to learned counsel for the petitioner in court. So learned counsel for the petitioner seeks adjournment. This matter on 1 week.
And in those 2 cases also they filed contempt, and the contempt has been dropped in those 2 other
Come
cases.
next week, my lord.
I'll circulate in the instruction.
81.
Please, lordship. Control the order dated 25/11/2022, my lord. The annexure 1 page 11, my lord. My application. Direction is that, my lord. The extent
It's been filed, your lordship.
my lord, petition was filed in 2024, my lord. The order is, my lord, 25/11/2022, my lord.
Still,
Thereafter, I have filed a first contempt, thereafter this is the second
No,
complaint.
first
This is the provisional pension, my lord, extension to the petitioner, my lord.
no, first, second.
Matter regarding provisional pension, my lord.
It appeal, provisional pension,
Yes, my lord.
which item?
81. Petitioner after retirement is crisis the financial, my lord, condition. Is the financial condition very poor, my lord.
What is the order?
Order is, my lord, on page 11, my lord. In my contempt petition, paragraph 4, my lord, I am reading, my lord. Therefore, in view of the reason stated in the detailed order dated 3/11/22 passing WPC number 28968/2022, this read petition stand disposal of in turn and said order, and accordingly this court modify the order dated 12/8/22 under annexure 3 only to extend that
Where is the
the
appeal?
provisional pension shall be paid petitioner.
So where is the appeal pending?
My lord?
Appeal is pending.
Yes, your lordship.
Yes, my lord.
So what is the number of that appeal?
1041 of 2024, your lordship.
No. If some writ appeal was pending, when this order was passed 25/11/2022.
Yes, your lordship.
What is that?
My lord,
What is the number?
It's 24.
appeal number,
Then why have you filed this contempt application?
I'm challenging the criminal appeal, my lord.
Tribunal, please come to the order.
That's me.
So where is the order passed in WPC 28968 of 2022?
This one, this is the 28968/2022. This is the.
Your lordship, it's a criminal appeal, your lordship. They prefer a criminal appeal, wherein BRLA number 317 of 2022, which is pending before this honorable High Court. Yes. Conviction, against the order of conviction.
Whether this order is under challenge?
Yes, your lordship. It's under appeal bearing criminal CRLA number 317.
No, whether this appeal is under this order is under challenge, 311
No,
WA 1014 of 2020, 1041 of 2024.
that appeal is not been challenged, my lord. That appeal not been challenged.
Which appeal?
CRLMC number. CRLMC 317/2022. That's not been challenged.
which writ appeal, please tell me, madam,
Yes, your lordship.
he is alleging disobedience of this order. This order has been passed on the basis of order dated 3/11/2022.
Yes,
Your
ma'am.
lordship.
That order was passed on the same day when the matter was taken up.
Yes, ma'am.
Now, you have filed appeal. You have filed appeal against which order?
Lordship, writ order, your lordship.
Huh?
Writ petition order, your lordship.
Which this 27718
Keep it to 2 PM, I will give the details. Sir.
next week.
Next,
And please let me know whether
My
this
lord,
order is under challenge or not.
my lord,
Yes,
this in my read petition 27/7/2008 read petition has been challenged. That previous read petition that has not been challenged, my lord.
Very good.
82.
We had filed a writ appeal against 27718 of 2022.
Read a bit.
No, this is. This is complied, your 82 is complied, your lordship.
82, they have filed a compliance affidavit, but wrongly. They are not complied. I have got some information. If your lordship permit me, I can file an affidavit to that effect. Lordship will keep this matter next week or
Let me see the order first.
my lord. Lordship, I will turn to page 11 of my brief. The order passed by this honorable court on 21st April
Which
2023.
annexure?
Annexure 1, my lord, page 11.
Annexure 1.
Page 11 of the contempt petition. The operating portion is at page 12. Paragraph 8, man. Because the sum of the land is lower, man.
So your representation was required to be examined.
Yes, my lord. Thereafter, my lord, what happened? They didn't comply with that direction, my lord, for which I filed a first contempt. In the first contempt affidavit,
Question of first contempt. See, you get the writ petition was disposed of on the very first day. Who were parties to that writ proceeding?
writ petition, my lord.
Yes. So you allege encroachment,
Yes,
you file a writ petition. You allege encroachment by a particular person.
my lord.
Then the writ petition is disposed of on the very same day,
My lord.
whether there is any encroachment or not, and whether that person has.
For that
encroached.
reason, this honorable court directed to conduct an inquiry.
Yes, yes,
Inquiry, and in case encroachment is found,
yes.
that shall be removed.
Yes.
That was the direction. And the encroacher was also a party to the writ petition, my lord.
Huh?
Encroacher was also a party to the
He was not noticed.
Since she was not noticed, direction was issued to conduct an inquiry.
All right.
Inquiry has been conducted, your lordship.
Inquiry has been conducted and they filed an affidavit, the compliance affidavit, my lord. They have stated that that land has been settled in her name. That land is road, my lord.
No, your
So your
lordship.
lordship knows that road cannot be
You
settled.
can challenge that.
And I have obtained certain information on the RTA Act.
Therefore, Mr. Counsel, the writ petition ought not to have been decided on
Then your
the.
lordship may grant me liberty to challenge that.
Disposal of representation has been disposed of. Dropped. Liberty. Yes.
83 last.
83 complied, your lordship. Speaking order has been passed, your lordship.
Yes. Dropped.
84.
84 also speaking order. Speaking order has been passed. 84.
Speaking order passed.
85. 85.
Complied.
86.
86 also complied, your lordship.
87.
87 also complied.
Yes.
88.
88, your lordship, encroachment has been removed, your lordship. 88 encroachment has been removed, your lordship.
Yes. Complied.
Encroachment has been removed.
Encroachment?
Has been removed from the land, government land. 88.
Complaint? No, they have no.
Yes, they have.
No, they have not complained. They are simply there. While taking instruction, they have complied with it. They have taken instruction from my client, they have complied the
What was
order.
the order? Let me see. So even without compliance, your contempt application can be dismissed. Let me see. What is the order?
88.
I have no information, my lord.
What is the order?
That is 4/12/2023, my lord. This honorable court pass an order to Ladakh Council for the petition has submitted that the petition is aggrieved on account of the encroachment in respect to which proceeding early case number. Sorry, ma'am. In the result, the writ petitioner stand disposable with a direction to opposite party number 4 to ensure the immediate removal of the encroachment with the
She is saying that the encroachment has been removed.
writ application order, my lord.
She is saying that the encroachment has been removed.
No, I have no instruction. I will take it. Next date, my lord, I will take it.
All right, next week, Run Council and AGA appearing on behalf of the contenders has submitted that the concerned encroachment has been removed. Submitted based on instructions that encroachment has been removed. So, when counsel for the petitioner seeks adjournment to seek instructions, is this case next week?
89.
We have proved the rushing matter. By the annexure to London ASC was took time for 6 weeks time to comply the order matter. Till date is not been complied matter.
Where is the order?
What is annexure 1 matter? Page 12 is the relevant portion matter. In the result, paragraph 8 matter. In the result, the writ petition stand disposed with a direction to the opposite partner 2, that means the contempt matter, to bring down the dilapidated structure standing over the scheduled land with a fortnight from today. It is also directed the petitioner shall honor and obedience to the order under annexure 4 shall remove the earth, the shell land within above period without fail matter. I have complied matter, but that the opposite partner 4 is not compliant. The contempt is sitting over the matter since long matter, and he is telling you nothing will happen to me. It will be first contempt, second contempt, then third contempt. Is saying so, my lord.
The writ petition was one.
Yes, ma'am.
The order was one. And the there was first contempt, and then second contempt, and then third contempt.
The opposite partner is obstructing
opposite party authority, nothing. He
has heard matter. He has heard before the first heard. The opposite partner has heard before the Tahsildar matter. Opportunity was given matter.
Who was the opposite party?
Opposite partner 4, sorry, matter.
Opposite party number 4.
Who is the obstructing my road matter?
Obstructing.
Yes.
Was he heard before this court?
No, matter.
Then why should this order be implemented at all?
But in the
opposite party number 4.
But in the first contra application, London ASC took time matter.
First is different. Now this is for final disposal. Yes.
Seek instructions, Your Lordship.
1 week as requested on behalf of the AG. This is not done.
Item 90.
Obligement.
90 minutes. I'm semi pardon. I'm on that's VC minutes from that's.
Yes.
Yes, that is whether there is order is compliant or not. And AGA will address this on the.
It has been complied, Your Lordship, and accordingly, a hearing in a matter was conducted on 29/12/23 in presence of the petitioner, and his grievance petition, along with other enclosed documents, was submitted further to the Chief Controller of Accounts, Ministry of Home Affairs, Government of India, because they have the authority to concern the case and release the arrear amount in favor of the petitioner if he is eligible to get the said amount. His papers have been now forwarded to the Chief Controller of Accounts, Your Lordship, Minister of Home. Because they are the ones who are going to decide, your lordship. But the petitioner was given a hearing by the authorities, your lordship.
Yes. Whereas in view of these chance circumstances, as the contender has done well, Your Lordship has well appreciated by the what manner government advocate has stated. So since matter is pending before the authorities, so may they are
It was a grievance petition for the disposal, your lordship, for arreared pension, grant of arrear pension of his grandmother.
yes. That,
Where is
that
the order?
Yes, your lordship.
Where is the order?
order minutes I have not filed minutes.
You are not right.
Yeah, I may be permitted to file the next week minutes.
What order?
In course of the day, minutes order passed in the writ application minutes. That order concerning to minutes that the arrear of the minutes the Swatantrata Sainika Sanman pension scheme that the some enhancement has been made. That order was directed minutes to comply the other minutes.
No, sorry, I will not adjourn the matter on that ground. This is item number
91.
90 minutes. So may I be permitted to minutes? I will file minutes.
No.
Not to file, Your Lordship, may permit me to
How can I see what was the order?
Yes, minutes. So that I'm doing the course of the day.
Sorry.
In the course of the day, I will file minutes.
The petitioner in the present contempt application has, do you have a copy of the order? Has alleged disobedience of this court's order dated 9/8/2023, passed by this court in WPC number 2461 of 2023. Whereby the petitioner's writ application was dismissed with a direction to consider his representation. Stop. It is a specific stand taken on behalf of the opposite parties by AGA that the petitioner's representation has been considered and necessary recommendation has been made to the competent authority for grant of freedom fighters pension. In such view of the matter, I do not find any case of deliberate disobedience of this court's order made out. Stop the contempt proceeding is accordingly dropped. Yes.
Yes, I may be
91. 91 is complied, your lordship.
Right.
Yes. Also, liberty may be given.
Liberty.
92. Your lordship. Let the order sought to be complied is at page 10, if your lordship will have. I was about to be landlocked. Because of the encroachment.
So what is the order?
Order that your lordship will get at page 10, my lord. In fact, the operative portion is paragraph 7. Access to my house was about.
No, but again, the order was passed on the very first day.
This is
without hearing the other side. And what is the purpose of such order? How such orders can be implemented?
now they say.
Let me see the nature of order. To take necessary action.
Yes, sir.
Unauthorized occupants were pleaded as parties.
They were named in the writ petition.
Then
They were named.
in the writ petition, they don't have any opportunity.
Now that opportunity was extended by the Planet Tahsildar.
Maybe
As it appears in the
after this order, then
and it was found that they are encroached. They have encroached.
It's already been vacated, your lordship.
No, not vacated, because I have filed my
there was no direction to vacate.
removal of the encroachment.
This is too much. You come to the High Court with the allegation that such and such person has encroached upon the land.
My lord.
They don't have any opportunity of hearing. The writ petition is disposed of for whatever direction, and you are coming with the contempt application. At least the state ought to have been. One doesn't know, even if there is encroachment,
Yes, my
That may take some time for removal of encroachment. Who are we to decide the very first instance that do it within 1 month, 2 months, 3 months? That at least they should have been given an opportunity.
before this.
Contempt is a very serious matter. Contempt is a very serious matter.
Yes, Lord.
Contempt is for
I do
punishment.
understand. But
Contempt is not for compliance only.
because what the pattern of the order is being passed, even your lordship must have seen by now the first contempt, second contempt.
All right, first contempt, second contempt, Mr. Counsel, we don't go by pattern.
Oh.
We don't go by practice.
Yes, sir.
We go by what the law says.
Law says. Well, that is the consistent wordings we are every day hearing from the lordship.
That binds us. The law binds us.
Yes.
So we are bound by that.
Yes.
And in a contempt proceeding, see, the court is required to proceed only when the court finds that it was intention of the party to.
Deliberate and intentional.
If the intention is shown, then no person is going to be spared, howsoever high or low he may be.
Merit, that's
All right. So
I have left with no remedy at this juncture.
I understand. But this court has also its own limitations. Exercising power in contempt jurisdiction and
May I
exercising power
make
in.
one small prayer, my lord? Under the circumstances, without, I bow down before your lordship. Lordship may say that whatever the cause of action as alleged by the present petitioner may also can be urged in a fresh application, so that I can, otherwise this will be a hurdle for me to initiate the
I can
fresh.
understand. I'll surely save your rights and your remedies also.
Yes,
You cannot be rendered remediless.
yes,
The present contempt application has been filed alleging disobedience of this court's order dated 25/1/2024, passed in WPC number 1292 of 2024. Operative portion of which reads as under paragraph 7. Stop. The order was passed on the very first day when the writ application was taken up. Stop. The petitioner had alleged arrayed private persons also as opposite parties who had, according to the petitioner, encroached upon the public land. Encroached upon the public land. Stop.
making me landlocked, my lord.
Public land, rendering the petitioner's land, landlocked. Stop. Next, be that as it may. The proceeding has been initiated.
Yes, your lordship, proceeding has been initiated and for eviction, it was placed on 29/6/2024. We'll seek instruction.
29.
29/6/2024
AGA has
was the date for eviction, your lordship.
the eviction proceeding has already been initiated. Stop. In such view of the matter, I am not in time.
My reply is that with the GPRS photos on 30th June itself, next day, that it has not been fully complied, my lord. I am still landlocked.
According to you, it has vacated.
So, your lordship, they have started the proceeding and it was fixed on 29/6/2024 for.
Proceeding, it is not the vacated. Proponent counsel for the petitioner states that the encroachments have not been removed. So, next, the present contempt proceeding. I am not inclined to enter into such disputes in the background of the nature of order which was passed on the very first day when the writ petition was taken up. So, it will be open for the petitioner to participate in the encroachment proceeding if the same is pending and take appropriate recourse to law as may be available to him. He is wrong with the aforesaid observation. Yes.
93.
May I please, your lordship. This is regarding demarcation of a land, my lord. Direction was order is lordship of annexed.
It says operating portion page 10, your lordship.
Annexure?
Annexure 1, my lord, page 10 of the contempt.
Yes. What is the order?
So demarcate, this was the direction for demarcation, my lord.
All right.
Now, referring to what they say, they rejected it at page 12, my lord. They have related it to a WL case, West lease case.
You can challenge that.
My lord,
You can challenge that. The order is simply to dispose of.
yes, they have demarcated a wrong plot, my lord.
Maybe they did not have any intention to violate.
Your lordship, I give with that liberty, my lord, man, dispose of.
And counsel appearing on behalf of the petitioner, senior counsel appearing on behalf of the petitioner after some argument, seeks permission to withdraw this writ petition with her liberty to take appropriate steps in accordance with it.
94.
And that do, madam. Order dated.
The writ has been filed, your lordship.
Writ appeal is continued.
Let's just substitute the number, they are not giving the number, that is the problem for us.
Give the number.
They are not giving the numbers, so I am unable to that direction, file affidavit.
I can give you a number. Mr. Counsel, I can give you a number right from here. Sitting here, the number can be given.
Yes, sir.
Everything is computer.
They have not given that.
The moment you enter the number, the moment you enter the number of the writ petition and the date of disposal, you will get whether any writ appeal has been filed or not. Why are you? And you are such a experienced lawyer. Writ appeal.
95.
Complied, your lordship, a speaking order has been passed.
Speaking order.
96.
A speaking order has been passed on 13/6/2024.
Speaking order.
97.
I am for 97. 97. The order dated 18/7/2023, in which the Lawrence single bench by law passed the order of rejection and directed for reconsider the case of the petition. You also can turn to page 10, my lord, paragraph 7. The RSCP benefits have been allowed in favor.
Where is the order?
Order dated 18/7/23, ma'am. Page 10, madam, para 7. Operative cost.
Operative.
Para 7, madam, page 10. Direction part is page 11.
Yes.
Lordship, a speaking order has been passed, your lordship.
No, this is not speaking order. This is an action. This is 2353.
Yes,
Your contempt petition is
2353. Contempt.
Misuse instructions, your lordship, that on. I shall seek instructions that will come next week.
to take a fresh decision.
Yes, your
Let
lordship.
suppose affidavit be filed on behalf of the opposite parties, stating as to whether the court's order dated 18/7/2023 passed in WPC number, WPC OA number 1540 of 2019 has been fully complied with the law. 4 weeks. Yes.
98.
Complied, your lordship. A speaking order has been passed on 29/4/2024.
Complied with.
99.
99 also complied, your lordship. By a speaking order on 29/4/2024.
Complied with.
Item number 100.
Date will be.
100 also complied, your lordship.
Order dated. What is the date of the speaking order in the previous case?
99.
29/4/2024.
In item
In 98 and 99, your lordship.
98 and 99.
Item 100.
100 is speaking order has been passed on 25/4/2020.
25/4/2022,
2024, you know.
24.
101. Yours 101. Order has been passed pursuant to direction of the Supreme Court Mirrors. And his case has been considered by the Director of Municipal Administration and his case has been Mirrors rejected on merit Mirrors.
No, there is no representation on behalf of the petitioner. It appears from the submissions advanced on behalf of the opposite parties that the petitioner's case has been rejected by
The Director of Municipal Administration Mirrors
the Director Municipal Administration.
by his order dated 29/4/2024.
Municipal Administration, which municipality? Which municipal corporation?
No.
Which municipal corporation?
No, but this is Director of Municipal Corporation
Is the office of the government?
Government of Odisha. Director of Municipal Administration Mirrors.
Government of India, Government of Odisha. Yes.
102. It's 102 also speaking order has been passed plus by the Commissioner of Secretary Government in Higher Education Department Mirrors on 16/7/2024 Mirrors.
Section 724.
103.
Reminder, the writ appeal pending, Miller.
Writ appeal.
104.
No one appears. Dismissed.
Item 105.
Please to your lordship, Miller. The order dated shall not comply with the order. Miller. Order dated 21/8/2023. Page 11 of this, that is not complied. The order passed that my disciplinary proceedings should be finalized within 3 months. But they have till today, they have neither finalized nor any passing order. You let me turn to page 13, Miller.
So disciplinary proceeding has been concluded.
That is some lordship.
Disciplinary proceeding, Miller.
Seek instruction.
One time or so we get it.
2 weeks.
Oblige.
Item 106.
106 notes order has been complied with. Notes order has been passed by the Additional Secretary to Government in the School and Mass Education Department on 30th of April 2024.
30th of April.
Liberty wanted to join this.
107.
107 also notes order has been passed.
A copy of the order.
Complied with.
Obliged.
108.
May I please your lordship, I am appearing through virtual court Kalahandi. I am appearing from the side of petitioner. The order of this honorable court has already been complied.
All right. Complied with. Thank you.
109.
109, they have stated there was SLP is pending before honorable appeal.
SLP.
110. Sorry, 110.
Come in, just permitted to download. Certified copy may be returned back.
111.
Order dated 13/10/2003. 23 is not yet complied with it.
Yes.
2 weeks time I will see.
2 weeks.
112.
Supplementary.
Violation of the order under Annex 1, your lordship.
Just a minute. Just- 100. 100.
Annex 1, your lordship. 100.
Another list.
111, the lordship kindly come to page.
Please wait. Please wait. Please wait. Please. Just a minute.
102.
102.
112.
112. Yes. Yes.
No, lordship.
Order is at page 8 minutes. Paragraph 4. Appeal is pending laws. In result, the
So, lordship, can you glance at page 8, paragraph 4 minutes. Therein, my lords, the lordship has in that writ petition has granted as the status quo order, Your Lordship. The last line, there shall be status quo maintained in respect of the scheduled land, Your Lordship. Last line of the page 8, para 4.
My submission is that there is no contempt. There is a direction to dispose of the appeal. Till disposal of the status quo shall be maintained.
That is the crux of the case is that the status quo has not been maintained by the opposite party, the contempt of knowledge, because we have filed the appeal on 25/1/2024. 25/1/2024, well within before 30 days, Your Lordship. And within the meantime, they have demolished our shop room, that's situated in that civil line.
When?
That is the exact date, I have to ascertain, that is before the 25th. Now, submit for adjournment, I will take the instruction with regard to the exact date.
No. The petitioner has alleged disobedience of this court's order dated 12/1/2024. Only to the extent that the status quo order has been violated. Stop. Upon perusal of the order of this court dated 12/1/2024, it appears that the petitioner's petition was disposed of with a liberty to the petitioner to file an appeal under the provisions of OPLA Act and OPLA Act with an observation that if such appeal was filed within fortnight, the parties shall maintain status quo. Stop. When counsel appearing on behalf of the petitioner has submitted that in the light of the order dated 12/1/2024, the petitioner filed an appeal on 25/1/2024. Stop. However, before the petitioner could file the said appeal on 25/1/2024 within the stipulated time, the structure in question was demolished. Stop. There is no mention, however, in the application as to when, as to the date when the structure was demolished, despite the order of status quo. In such view of the matter, in my opinion, no case of deliberate disobedience of this court's order is made out for this court to initiate contempt proceeding against the opposite parties. The contempt petition, the contempt proceeding is okay. Contempt petition is dismissed. Yes. One week.
115.
May I please, I received the complaint but subject to concern that it is not compliant because due to general election they have taken time to conduct the Municipal bill after the election, but election is over last 3 months, but not yet. The selection process has already been completed.
What was the order?
Order is page 9, my lord, para 6. Order is person.
Yes, considering the facts and submissions, the opinion of 3 directed to dispose of the representation filed by the petitioner without ignoring her educational qualification suitability.
Next order.
Representation has been disposed of stating that the process will be completed after the election.
Thereafter, the lordship kindly have glass. This said repentances shall be distributed within a period of 1 month from the date of receipt of the order. In the meantime, selection process shall not be given effect without considering the case event. They filed the compliance order that due to general election, we have not conducted no election, just after we will do that. But in the meantime, the election has already over 3 months, but order has not yet been complied in the letter and spirit.
So her representation has been disposed of, saying that we will complete the process of selection after the election.
But selection process is not yet completed, my lord.
Where is your representation?
My representation dated 1/2/2023.
Where is that?
My lord,
Where is that representation?
that is in the writ petition at page. At page 25.
You are not filed. Then how can I see whether the order has been disobeyed or?
Connected file is with your lordship, my lord.
Huh?
Connected file is with your lordship. The writ.
There you are right. Let me see the order which has been passed. This is 2808. What is wrong? The-
My lord, your lordship, kindly have a glass to last portion of the order. Here is the view of the operation, modern code of conduct due to general election 2024. A suitable date for Mohila Mahasabha will be convened that meeting of the MCC in order to complete the selection process. The election is complete since June.
All right, there is no direction to conclude the selection process.
Yes, my lord, in the last portion of the order, there is the process of complete the selection. The ordering portion last sentence is in the meantime, the selection process shall not be given effect without considering the case of the present petition.
What are you saying?
My lord, at least writing to complete, so that will be
It is
again.
the direction to complete the process of selection.
So my lord, that will be hang years together, man. That will hang years together. Only filing.
You cannot put me in dock.
No, here, let's say, I'm not
Cannot put that.
I'm putting myself.
You
my
are
lord.
not putting that question to yourself. Had you put that question to yourself, you would have got the answer.
My lord, I have read for selecting me and complete
Then
selection.
you should have challenged the order.
Yes, my lord.
This was not this order, the order of this court. The order of this court does not indicate that the selection process should be concluded.
Lordship, my lord,
Why are you making the submission?
Your lordship, permit to.
In the court's opinion, the order dated 30/10/2023 has been complied with, in as much as an order dated 34/2024 has been filed, that has been passed by the CDPO Badrak. So the contempt proceedings stands stopped accordingly.
116.
Yes.
116. SLP has been preferred.
I will permitted to file.
Yes.
SLP bearing diary number 27089 of 24 is filed now.
Circuit.
Item 117.
Begging my lord's pardon, I may be allowed to receive my lord. Here order dated 25/7/2023 under Annexer A, page 9 has not been complied with, my lord.
Where is that?
My lord, at page 9, Annexer A of the contempt petition, my lord. page 9. Order dated 25/7/2023, my lord.
Very difficult. These orders cannot be complied with.
Page 10, paragraph number 8 of the order, your lordship. May kind
That I have seen. That I have seen. Who are the parties in the writ proceeding?
Here the parties are the collector, Tahsildar. Now here the present read for application. The parties are the collector, Tahsildar, and the private party. Those are the encroacher of the road.
Whether the parties were noticed.
Not noticed, my lord.
Very good.
Honorable court has directed to the collector, Tahsildar, to hear both the parties, all the parties.
Present contempt application has been filed alleging disobedience of an order dated 25/7/2023 passed in WPC number 22070 of 2024, which was disposed of on the same day when it was taken up. First off, there were private opposite parties in the said writ application who were not noticed. First off, the petitioner had alleged in the said contempt application encroachment by the opposite parties in the writ application over public land. Stop. This court disposed of the writ application with the following direction. Stop. With the following observation. Stop. What is yours?
Yes, they were given opportunity not, and after that they taken decision, the obstruction before the house of the, in front of the house of the petitioner has been removed.
It is stated by learned AGA that in the light of this court's order, proceedings are initiated for removal of encroachment, and certain encroachments have already been removed. Stop. In such view of the matter, in the court's opinion, no case of deliberate disobedience of this court's order is made out. Contempt proceeding is dropped.
118.
Obligement.
18 minutes, comparative speaking order has been passed by the minutes additional chief secretary on 9/4/2024 minutes.
All right, complied with.
I will give the
Liberty.
Sorry.
Yes.
119.
119, my lord, though there was some completion, my lord, but they have complied partly.
No, encroachment has been removed by the Tahsildar.
No, my lord, entire encroachment has been removed, my lord. As per their, my lord, notice under page 6 annexure B of their counter, there was
Come to the order first.
my lord. The order is, my lord, under annexure 1, the para 4 of the.
There is no direction for removal of encroachment.
No, there was a direction to took up that matter, and accordingly the matter was took up.
So who had encroached?
Well, a private parties.
Private party was noticed.
He was party in the writ application.
The petitioner has alleged disobedience of this court's order dated 18/1/2024 passed in WPC number 42543 of 2023. Stop. The writ application was filed alleging encroachment made over the government land by certain opposite parties. Stop. The encroachers were impleaded in the writ petition, but they were not noticed before the order of this court dated 18/1/2024 was passed. The following is the operative portion of the order, paragraph 4. So it is manifest that by the said order, the opposite party number 2 was required to consider and examine the petitioner's representation and take appropriate legal action. Stop. A legal action has been initiated.
Yes.
Initiated, my lord, initiated,
And
some portion of the encroachment has been, my lord, removed.
The counsel for the petitioner admits that process for eviction, process for removal of encroachment was initiated and partly, comma, the encroachment has been removed, but the entire encroachment has not been removed. First off, even if what is submitted on behalf of the petitioner is to be accepted, comma, that will not constitute deliberate disobedience of the aforesaid order of this court. This contempt application is meritless and is accordingly dismissed.
120 order has been complied with, so speaking order has been passed on 2/7/2024.
Yes. Speaking on the past. Yes,
121. 121 will comply.
complied.
Sorry. 122. 122 complied.
Complied.
123.
Well, arising out of an interim order passed by the Supreme Court, and the main matter is pending before the Honorable Single Judge.
Yes.
So blessed.
The petitioner has alleged disobedience of an interim order of this court passed in WPC number so and so, which is still pending. First of this matter along with transfer before an appropriate bench.
So blessed.
124. That relying one order, this order has been passed that has challenged that it pending before the Honorable Apex Court.
There is no representation on behalf of the petitioner. Contempt application is dismissed. Yes.
In this case, not that relying that Harapriya case was challenged before the Honorable Apex Court. In that case, that has been remanded for fresh adjudication here.
Which case?
That in 124, my lord.
So 124, you said SLP is pending.
No, not in this case SLP. That in this case, relying one order passed in Harapriya.
So that has been remanded.
Yes.
All right, I'm just dismissing it.
125.
May I please, my lord? You have received the second contempt, and intentionally the opposite party has not complied with the order of Honorable High Court dated
What is the order?
30/11/2023, my lord. Annex 1, my lord. Page 15. Page 15 depends on the petitioner and
This is not the order. Where is the order passed in the writ petition?
the order of the petition, Honorable High Court, mentioned that four kind C, referring to copy of the record rights as at Annex 3, as well as the matter of Annex 4, Laren Council for the petitioner submitted the private opposite party are in unlawful possession of the civil land, more fully described in Annex 3, and for eviction, the petition under Annex 1 and 2 have been submitted. However, no action has been taken there on till that. It is the condition is that the direction will be issued.
Forget, come to paragraph 9.
Yes, Miller. In the result, the report.
What is annexure 1? What was annexure 1?
Miller?
Come to paragraph 9.
Yes, Miller. That the opposite action of the opposite party.
In the result, the writ petition stands disposed of.
Yes, Miller. In the result, the disposition stands disposed of is a direction to the opposite party number 4 to consider and examine Annex 1 and thereafter to pass necessary order according to law.
So whether Where is annexure one? Annexure one has been considered or not?
Not, no, my lord. Agenda does not consider my representation.
In his synopsis, he has said that some of the encroachers have been evicted. I'll take instructions so far what has been happened in his.
No, there is no question of it was a question of consideration of his representation.
And as per the order of honorable court, in concern matter,
96 of private opposite parties in the writ application.
And he has admitted also in that his synopsis, some of the encroachers have been evicted.
but as per the order of honorable court in content number, of content number,
I will not. Mr. Counsel, no contempt. The contempt is of the original order. No, this order cannot be modified in contempt jurisdiction.
yes, my lord, but not communicated to me any error, any letter.
You know better. Since you knew that they have encroached, you must be knowing that some of them have been removed. The petitioner.
But private opposite parties are there,
This court
5
thought
to
it-
97 Miller.
this
Only 20 encroachers are evicted there.
7/2023, whereby the petitioner's writ application was disposed of with a direction to consider to examine his representation. With a direction to the opposite party number 4 to examine the petitioner's representation. First off, it is apparent that the petitioner had represented against encroachment.
Yes.
Represented alleging encroachment made by about more than 90 persons who were impeded as opposite parties in the writ petition. First off, they were not noticed before the order of this court dated 11/7/2023 was passed. Land counsel appearing on behalf of the petitioner admits that after considering his representation, some of the encroachments have been removed, but some encroachers are still illegally occupied, are in illegal occupation of the public land. So, taking into account the fact that the opposite parties contemners took steps for removal of encroachments based on the petitioner's representation, this contempt application cannot be maintained on the petitioner's contention that some of the encroachers are yet to be evicted, who were though made parties in the writ petition, but not noticed while passing the aforesaid order dated 11/7/2023. This contempt petition has no merit and is accordingly dismissed.
126.
126 SLP file.
SLP.
127.
SLP file, man.
My lord, in 127,
128.
Order complied. Yeah, you have liberty on them.
129.
Order complied, man.
130.
Did not cooperate.
130,
129, 130,
132 weeks time.
129 compliant.
129 complied.
Yes, 130.
132 weeks time.
Yes.
131.
131 also sent to 2 weeks time.
My lord, you have received the order, you can start in the writ petition. But paragraph
I am seeking 2 weeks time for compliance.
2 weeks.
132.
132 is similar to 125.
No. So 132 is a separate matter.
Separate.
This is also a second content. Now, again, that now the container has not complied the order of honorable High Court.
Yes, let me see the order. Where is the order?
Yes, similar. Time is similar. Page 200 similar.
Where is the order of this court? This is different.
Yes, Miller. Kindly see page 17, para 9, Miller. In the result, the restriction can distribute which a direction to the applicant number 4 to consider and examine annexure 4 and to take up the demarcation if the really necessary and thereafter taking into account the grievance of the petitioner and other.
First writ petition was filed by whom?
Yes, Miller.
The earlier one was filed by whom? The earlier writ petition, which was disposed of, was filed by whom? No, by another person.
Another person, Miller.
By another person.
Yes, Miller.
Same lawyer.
Same lawyer, another person. Miller.
Yes. So where is the disobedience? Whether the parties were heard or not?
Yes, Miller.
Whether they were noticed or not, there are 30 opposite parties.
Yes, Miller.
Right from 5 to 32.
32.
So whether they were noticed?
No notice is there, Miller. And no instruction to me were not communicated to any letter to me, Miller. Again, that I will not.
Show me the representation
Representation
which you had filed.
4, Miller. Annexure 4 in the restriction, Miller.
Where is that?
The respect.
What is the date of representation?
Miller. Can you see writ of the petitioner? Restriction of the petitioner.
Yes.
Annexure 4, Miller.
Okay. What is the date? What is the date?
That is the date, Miller, 23, 06, 23, Miller. Representation letter 23, 06, 2023, Miller.
2023. 2023.
Yes, Miller.
When did you file the writ petition?
The restriction is filed below, Miller, on the 3rd, 11/07/2023, Miller.
11/0?
11/07/2023, Miller.
And it was disposed of on?
And the disposed of on
why cost should not be imposed on you? On 23/6/2023, you file a representation.
Yes, Miller.
Within less than a month, you approach this court for disposal of the representation. And that representation is disposed of, the writ petition is disposed of on 27/2023.
Yes, Miller.
In the meanwhile, the private parties have no knowledge. And show me the representation. Show me the representation. Give your writ petition.
Yes, Miller. Representation, Miller.
Just a minute.
Dated 26/2023, Miller.
Yes.
Annexure 1.
Just a minute. If you are abusing the process of the court, then we have means to stop you from doing that. Show me from this, when was the representation received?
First representation, Miller.
First representation. When was the representation received?
26/04, Miller, 2003. 26/04/2023, Miller. On that one,
File your representation on 23/6/2023, you just now said.
Miller, the contempt has.
I am going to order for an inquiry. In this case, I am going to order for an inquiry. All right. Look. the present contempt application has been filed alleging disobedience of an order dated 27/2023 passed in WPC number 21777 of 2023, operative portion of which reads thus. First off, it is apparent from this court's order dated 27/2023 that it was disposed of on the very same day when it was taken up, without waiting for taken up. First off, further, by the said order, the petitioner's representation at annexure 4 to the writ petition was directed to be disposed of. First off, annexure 4 of the writ petition has not been brought on record in the present contempt application. First off, I have seen from the original records of the writ petition that annexure 4 is a representation dated 23/6/2023. First off, within a month from the said date, the petitioner filed the writ petition on 11/7/2023. First off, on 27/2023, this court directed for disposal of the representation which the petitioner had filed on 23/6/2023. First off, on perusal of annexure 4, I am of the prima facie view that there is no proof of receipt of the said representation by the competent authority. So from next. Let the Registrar Judicial Odisha High Court conduct an inquiry as to whether the said representation which the petitioner claims to have filed on 23/6/2023 was in fact filed by him or not, and submit a report to this court for passing appropriate orders. Plus this matter 4 weeks as the first case.
133.
133 मतलब SLP file.
SLP
134.
मतलब complied.
Liberty to approach.
Liberty
135.
135 complied.
136.
136 complied.
137.
So 137 1 week time instruction.
138.
none of yes.
139.
Dismissed.
Also complied.
No, my lord. One not complied with.
130.
139.
138 are complied. That I'm saying 138.
138 compliant.
139. 139. 139. Lordship, can you see the order dated 16/11/2022, my lord. 16/11/2022.
Where is that?
Page operative party page 12, my lord. My content page, sorry. Bottom para 7, my lord. Considering the submission to restriction of disposal by the stage of admission without the expressing an opinion on the merits of the case by directly opposite party number 2 to remove the retired benefits of the petition as is due and admission by deducting a ₹1 lakh within a period of 3 months from the date of production of the certificate of this order. Petition is retired from 2012, February 12. Because of the pendency of the departmental proceeding, he was not getting his pension, man. Proceeding is completed. The 1 lakh 79,000 recovered. That has been dropped, man.
thereafter no pension benefits has been given.
Yes.
Let me see the last question.
Hmm?
That order, madam. That to release the retirement benefits of the as is due and admissible by deducting a sum of rupees 1 lakh within a period of 3 months from the date of production of certified copy of this order. Further, the petitioner is directed to cooperate with the departmental proceeding and shall appear before the receiver as and when required for the purpose, since it is submitted that the source has already been submitted on 13/12/2021. The disciplinary authority is directed to conclude the same within a period of 2 months from closing. That proceeding has been concluded and he has been imposed with the punishment. Now, madam, in the meantime, he has been directed to submit all the pension papers and that will be released.
You also kindly see I have given the reply to it. Procedure complete the period of suspension from 75 to 2008.
So you can challenge that. You can challenge. The proceeding has been concluded. This was the direction. The proceeding has been concluded.
Concluded, no, there is no recovery. There is no recovery in the proceeding.
Punishment has been imposed.
There is no recovery, my lord.
All right.
Because of the there was 79,000 recovery, proceeding was initiated. Now they have what is the punishment that what he is saying, my lord. The period of suspension will be treated as leave as punishment, my lord, and the day is sanctioned. The petition will be retired from the 2012, my lord.
So
I'm entitled to make all the retirement benefits.
give him retirement benefits at least.
Well, he had to submit his pension will release because the punishment was imposed on 2023. So that period was to be, and some benefits has been also released in his favor.
Nothing has been given. Pensionary benefits, my lord. Provisional pension, monthly pension, they are saying that that is the retirement benefit. I have gone through my reply to this. They have said that
So other retirement benefits are concerned, if any, that will be released within 1 month, my lord.
Which retirement benefits? Isn't
they
this
are
one?
not actually, my lord. I am entitled to 22 actually.
Release the retirement benefits of the petitioner
Yes,
as is due and admissible.
Yes,
within 4 weeks, all the, because
4 weeks. Discuss matter on 4 weeks. Talk about. In the meanwhile, the court finds that this court's order dated 16/11/2023 has not been complied with fully by releasing the retirement benefits in favor of the petitioner. The court shall consider initiating contempt proceeding against the concerned officials. Yes.
from 140, the state is not a party, but instruction is that has been complied.
the copy I have not received.
No,
40 compared with
131. My lord, consequential benefits as directed, my lord, by his lordship, that has not been extended, but he was reinstated in service. But the consequent benefits.
Was there in direction?
No, my lord, the judgment, my lord. The judgment page 37. Operating parts. Starts from page 11, operating parts at page 37, lord. My lord, the middle page 37, the authority shall treat the petitioner at par with her batchmates and shall take steps for regularization of her service against any available vacant one with all consequential service benefits.
Yes, so for the other side.
My lord.
My lord,
So page 49 of the content petition, my lord. Page 49. Pursuant to the judgment of this honorable court, the petitioner reinstated, my lord, and also given the benefit annexed 6, my lord.
My
What is there?
Only consequential benefit.
Consequential benefits, everything has been given. No work, no pay.
No, Lord, the pay is to be fixed notionally, my lord. That has not been, pay has not been fixed.
You can-
Your lordship may dispose of the granting liberty, my lord.
After having seen the office order dated 8/12/2023 passed by the Director Municipal Administration, bracketed annexure 6, I am satisfied that this court's judgment dated 24/3/2023 passed in WPC number 25947 of 2022 has been fully complied with. Full stop. Then counsel appearing on behalf of the petitioner has submitted that consequent upon his reinstatement pursuant to this court's direction, he is entitled for certain more benefits which have not been given. Stop. The petitioner shall be at liberty to raise such grievance before appropriate forum in accordance with law.
142.
I may be granted liberty to file approach.
See, I have just given you liberty to do whatever you want. Nothing more than that.
142.
15 Professor. As per order dated 15/9/23 has not been complied. As page 10 is the interim order receipt.
Complied with.
No, Mr. Not complied, Mr. Page 8, page 10 receipt.
Where is the
Paragraph
order?
8. That's page 10. Paragraph 8. That's it.
Difficult. That encroachment from public land.
That's it. Agricultural land.
Who had encroached?
That's OP number 4 and 5 in the OP.
4 and 5 were noticed.
No, no. Sir. Then. Actually, the annexure 6 period.
Yes, my lord. That encroachment case is disposed of, and against that they have gone for the appeal. That appeal is pending before the sub collector.
Was liberty may given will intervene in the appeal.
And counsel for the petitioner after some argument seeks permission to withdraw this contempt application. Stop this contempt application is dismissed as withdrawn.
143.
That is speaking order.
Yes, speaking order.
You were 144.
What was complied with me? Meet previous lordship. Lordship, can you turn to page 5 of the brief, my lord? Order dated 17/10/2023 passed by this honorable court in WPC number 31082 of 2023.
Which order? You are alleging violation of which order?
Order dated 17/10/2023 passed in WPC.
Oh.
WPC number 31,000.
You are in another list, Mr. Counsel. This is not your case.
144. Weekly.
144 complied with.
Complied with.
145.
145 miles complied with.
146.
146 my lord. Order dated 7/2/2024. 7 February 2024 my lord. Order dated.
So it is complied with or not? Which item?
146 item.
146. What is the order?
order the 7th February 2024, kindly see my lord, page 11, my lord, annexure 1, page 11, para 7, my lord. I have already filed representation, my lord. Representation filed on 20th February.
Order for the removal of enforcement, order for the removal of enforcement, my lord. And on the first day, this was disposed of, my lord.
Order for encroachment has been passed.
No, order to removal for the enforcement. And on the first day, my lord,
What can be done in such cases? Submit a representation.
Already represented filed, my lord. 20th February 2024, my lord. And 22nd February 2000 postal.
File your affidavit.
no.
4 weeks.
147. 47, my lord, the state has filed the SLP and that has been allowed, my lord.
Item
147. 47. Yes, sir. Non-appeal.
on appeal.
That has been allowed and remanded to.
148.
Petitioner. It has been stated that appeals were preferred. Special leave petitions were preferred before the Supreme Court, arising out of the order which is a violation of which has been alleged in the present contempt application. Of the said appeals have been allowed by an order dated 11/9/2024, passed in batch of order dated so remanding the matter back to the High Court of such view of the matter. No case for initiation of contempt proceeding is made out. Application is accordingly dismissed.
148.
Now, state has filed SLP number 13744/2020.
SLP
149.
That's a grant some time.
2 weeks.
150.
50 also grant some time.
151.
No, there is speaking order. No.
152.
Grant some time, man.
Also, there's a matter relating to for appointment of fourth class employee madam. Since 2000, the matter is pending. And in 2023, yes, sir. Since 2000, the petitioner is running from pillar to post. Forget the job now. So Lordship may kindly see page 10 of the order, madam.
152.
Yes, sir. Annexure 1, page 10, madam. The last part. Last para, madam. Since it is found that the opposite part number 3 has not indicated anything about the vacancy position in the year 2000 and the suitability of the petitioner, this court is inclined to quash the order at annexure 1. While quashing the same, this court directs the opposite party number 3 to consider the case of the petitioner, taking into account the vacancy available in the year 2000. It is observed that if in the year 2000 vacancy of the class 4 post were lying vacant, the case of the petitioner will be considered in the light of the order passed by this court in OGC number 4325 of 2000. Such a fresh decision shall be taken by the opposite number 3 within a period of 2 months. And till that matter, the order has not been complied, and the petitioner is now, my lord, he has become a handicapped, my lord. Now, my lord, there's
Why this order was, what was the order passed in OGC number 4325?
my lord, will also may kindly see page 8. The operative part is quoted here. Page 8. In view of the limited grievance of the petitioner, the writ petition, the writ application is disposed of with the direction to the opposite party number 4 to sponsor the name of the petitioner if the aforesaid posts are lying vacant in the office of the collector and district magistrate, and requisition is made for appointment to these posts.
There is no order, nothing.
And
No
there are-
adjudication.
nothing has been done, my lord.
No adjudication at any level. Failure. 2 weeks.
Date will fix, my lord.
2 weeks.
My lord.
153.
No, no, SLP is filed, man. 7910/2024.
154.
No, SLP is filed, man.
SLP number.
Died number 20707 of 2020. 20707.
155.
Compliant.
Compliant.
156.
Non-compliance of order dated 15 February 2024.
Yes. Yes, sir. Complied with or not?
No, no, I think I'll grant some time.
2 weeks.
157.
Please, your lordship. Well, the order dated 7/2/2024 has not been complied with by the OP number 3, my lord. Despite specific direction, rather, the OP number 3, in defiance of the court's order, my lord, continued the construction work. The lordship may kindly see, come to page 12. Annexure 7, my lord, to the contempt petition, my lord. That is the photograph where the OP number 3 is standing with his staff. OP number 3 is standing with the staff.
OP, who is OP number 3?
My lord, Tahsildar Khoira, my lord. It was specifically directed by the Honorable Court by order dated 7/2/2024. The lordship may kindly come to page 11, my lord.
Mr. Counsel, what is this? What is the order?
My lord, order was directing the opposite party number 4 to dispose of encroachment cases, severe number of encroachment cases of the petitioners.
Encroachment cases filed by the petitioner.
There are 7 petitioners, my lord.
7 petitioners.
My lord.
Several petitioners. Against how many persons?
7 persons, my lord.
7 persons.
My lord.
So whether they were heard?
No, my lord.
They were not heard. So they don't have any right of hearing.
No, my lord, the petitioners in the contempt petition are the petitioner in the writ petition, my lord.
Yes, yes.
Ballot on by order dated 7/2/2024, my lord. An order was passed by this honorable court. The lordship may kindly come to page 10, my lord, of contempt petition, my lord. And it was specifically directed by the honorable court, directing the OP number 3 Tahsildar for disposal of all the encroachment cases, my lord, within 12 weeks from the date of receipt of the copy of the order. And without implementing the encroacher, my lord. They are not the party. Encroachers are the petitioners are the encroachers. Since they are
if the petitioners are encroachers, then just leave it, leave the.
No, my lord, encroachment cases are pending with the OP number 3 since 2017
against you.
against all the petitioners.
Then
And without, my lord, disposing of the encroachment cases, the OP number 3, 2 and 3 started evicting the petitioners.
Then-
They are in long position for last about 60 years more, my lord.
then what
They
happened?
are poor laborers.
Then what happened?
Then the petitioners approached this honorable court in WPC number 2724 of 2024. And thereafter, on 7/2/2024, my lord, this honorable court directed the OP number 3 Tahsildar to dispose of all the eviction proceedings and then to proceed in accordance with law. But without my lord disposing of the encroachment cases within the time as per direction of this honorable court within 12 weeks, my lord, 12 weeks expired. But the Tahsildar did not dispose of the encroachment cases. Rather, on 22/2024, my lord, when the certified copy of this honorable court's order was produced before the Tahsildar, he threw it to the petitioners and misbehaved the petitioners, my lord, that I am not going to comply the order of the court because I am a servant of under the state government. That is specifical, and this fact was also brought to the kind notice of the honorable court, my lord, in IA number 3172, which is on record, my lord. I have obtained the instruction, my lord. The petitioners are not the landless person. They have agricultural land and they have wherever. Besides this, they have already forcefully occupied the government land.
They have occupied.
Occupied the government land and they are submitting that to settle that land in their favor. They are not landless person.
So why have you not removed them from the?
We have taken steps for removal, man.
So remove them. Remove them by the next step.
But after disposal of the encroachment cases, if they will be removed after disposal of the encroachment cases, my lord,
Yes.
that order should have been complied by the Tahsildar OP number 3, my lord.
Yes, sir. So that will be.
So without disposing of the encroachment cases as directed by this honorable court,
Whether encroachment cases have been disposed of.
no, my lord. Now that has to take my consider about the view of the Tahsildar that they are not the landless person, my lord. So for who the land can be settled in their favor?
No, land cannot be settled.
My lord.
These any cases are pending or what?
That part I will take instruction, my lord. All the cases are pending, my lord. No notice and
All right.
my lord.
I'll keep the matter pending till the any
My lord.
cases are disposed of.
My lord.
All right.
My lord.
That will happen.
My lord.
As requested on behalf of the opposite parties, this matter on 2 weeks for him to inform this court as to whether LE case number 1059 of 2017-18, LE case number 1057 of 2017-18, LE case number 1054 of 2017-18, LE case number 1060 of 2017-18, LE case number 1053 of 2017-18, LE case number 1058 of 2017-18, and LE case number 1055 of 2018 have been disposed of or not. Yes.
Madam.
158, item number 158.
Order, madam.
And the non-compliance of dated order 2/8/2023.
Speaking order has been passed.
This has already been received, my lord, but this is not the order been given as per the court, seeing the court judgment, my lord.
Where is the order?
My lord. Page 7, my lord. Of the contempt, second contempt, my lord, the second contempt,
No, I'll not seek any contempt order. I'll see the order passed in the writ petition.
my lord. Page 10, my lord. Page 9. It's been
Paragraph 5.
Paragraph 5, my lord.
So whether your petition has been disposed of or not.
That is, they have stated that this decision is to be taken by the higher education, my lord. But this has been directed to the SME, school and mass education, my lord. And this second contempt petition also, my lord, we have not made a party to the higher education because higher
Mr.
education.
Counsel, I'll not see any order passed other than the order passed in the writ proceeding.
My lord.
In the writ proceeding, opposite party number 1 was directed to take a decision. Whether opposite party number 1 was competent to take a decision.
They were actually, during the disposal of the writ petition, they were to take.
What are they saying now?
They said that they have a policy decision been taken in 2023 and 24.
That.
Later on, my lord. 2018, it's been long.
What can be done? See the nature of the order. There is absolutely.
I can amend the petition by challenging making party to the higher education, my lord.
No. The present contempt application. The petitioner raised disobedience of the sports order dated 2/8/2023, passed in WP OSC number 1520 of 2018, whereby the writ petition was disposed of with a direction to opposite party number 1 to take a decision on the petitioner's representation. So stop. The representation has admittedly been disposed of. Also, the learned counsel appearing on behalf of the petitioner has questioned the legality and propriety of the said order. So stop. The said aspect cannot be gone into in a proceeding under contempt jurisdiction. The contempt proceeding stands dropped accordingly. Yes.
159.
Yes.
This is also case, my lord, the directing for removal of the encroachment, my lord. Page 7, I.
My lord, this matter is the regularization of service.
No.
Weekly.
Upon supplementary.
There is no representation on behalf of petitioner. This contempt petition is dismissed.
Item 160.
That is speaking order.
Yes. I'm direct.
161.
161 SLP file. 161
Yes.
SLP file.
162.
160 filing a Sophos affidavit. Actually serving a copy on my
Compliant?
and here it has been complied. Your lordship may kindly see the order. Conduct an inquiry vis-a-vis the alleged encroachment. In case encroachment is revealed, to take steps for removal. This was the direction. Now pursuant to that, an inquiry conducted, inquiry report received, then notices were issued to all the parties. Some of them did.
proposed affidavit has been filed on behalf of the contenders, which is taken on record. So, from the proposed affidavit, it appears that in the light of the court's order violation of which has been alleged in the present contempt application, steps have been taken for removal of encroachment with issuance of notices to the concerned persons. Stopped. Accordingly, present contempt proceeding is dropped.
Item 163.
Appears.
Your Lordship, 163 and 164 infractions.
Infectious.
165.
165. 165.
Complied with.
166.
166 compliant with the body.
Compliant liberty.
167.
Order dated.
But madam, you are appearing in which case? You are appearing.
Sorry.
My lord, I was appearing in the matter of 165.
So why what happened?
My lord, this is a contempt of court case, my lord.
Happened.
Compliant.
Do you want to say something?
No, my lord. Appeals.
167.
67.
Order 67, my lord, writ appeal pending.
Yes.
168. 168.
68 also, my lord, writ appeal pending.
Writ appeal has
My lord,
been
here writ appeal has been disposed of.
dismissed.
Your lordship, may kind
Yes,
of see
that
the
will
first
make
in the writ appeal. That was disposed of in terms of the judgment of Bindu Sagar Samantrak, that case which is pending in SLP. Your lordship may grant us some time so that until dispose of that case.
6 weeks, you file your reply.
6.
Yes.
169.
Please, Your Lord, similarly, they have filed the writ appeal. 247 by 2024, pending it is, and writ appeal is pending.
All this in the field. You are blaming them for filing writ appeal, no?
No, because
Or later.
169.
Hmm.
169.
169, there's
Supplementary or weekly?
appeal,
Get a weekly charge.
weekly, sir.
sorry, madam.
169 already complied.
Complied.
Item 170.
170, my lord, his pension papers have already been processed and sent to the accountant general. That
Please ensure that these matters are expedited.
I'll, for 2 weeks time.
Accountant general is not a party.
Accountant general. Is
a party.
No, sir. Party. Party in the contempt. Sir. Accountant general, Mr. Patra, S. Patra was appearing. Was there first hour.
Have you served a copy?
Yes.
Have you served?
Content copy.
Huh?
Content copy not served.
What does this matter on 2 weeks? Also, in the meanwhile, let a copy of the contempt application be served on Mr. S. Patra.
Yes.
Learned counsel who represents the office of the Accountant General.
Sir. Accountant general.
The Accountant General.
171.
From 171 to 177. There is a batch of cases disposed of by a common judgment. In the lead case, today we have filed the writ appeal. In other cases also we are filing.
Did it come after a week?
Fine.
Okay. All these matters.
Item 179. Item number.
Second one, not complied, madam. Order dated 21.
178.
79.
Withdraw.
Withdraw.
27/21, my lord.
170.
Yes, very
One second. Order dated number 27/21, my lord. Page 3. And page 4. Considering the limited nature of the grievance raised by the petitioner.
So whether it has been done or not,
Hmm?
whether some order has been passed or not.
No, my lord.
Yes,
Yes, my lord. Order passed, already passed. I am serving it.
all right. Compared with
180.
Not compliant. Retired person paying for pensioner benefits. The man is also suffering from cancer.
180, my lord, Writ appeal is pending. my lord.
Then, kindly see the order, my lord. Order is that others have been given, we give the benefits, and that man is suffering from cancer. I have also included the certificate, the medical certificates. The second contempt also, my lord. Second, 2 writ petition, that second contempt. Right? Kindly see the order, my lord. Kindly see the only one paragraph is submitted, my lord. Kindly see. Page 15, paragraph 6. Page 15, my lord. On the basis of the instructions submitted to state council order in past. On instruction to summary and additional fairly contended that person similar schedule time which is extended.
again, this writ appeal has been filed.
That others have been given the benefit and those admitted.
Whether others have been rightly given benefit, this is on the basis of instruction.
Yeah, they are giving instruction, because my lord, accordingly, I am changing the director to extend the same benefit petitioner. And that, and this is second, first rejected, second time also passed the order.
Writ appeal. Yes.
181.
Then, ability.
181. Writ appeal is pending, your lordship. 181 writ appeal is pending.
After long lapse of 6 months, they may have had. No limit, no notice has been issued, limitation also.
182.
82 passed. A speaking order dated 27/20/24 has been passed, your lordship.
Yes.
Your lordship will not decide the copy.
Whether her periods have been regularized, your lordship. The suspension period and so as the joining period.
Everything has been done.
Hmm.
Compared with.
My lord.
183.
183 also, your lordship, but speaking order has been passed on 20th of July 2024.
Yes.
And 184.
84 also, speaking order has been passed, your lordship. Fourth, Departmental to
Withdraw.
185.
Non-compliance of order dated 9/8/2023.
From 185, 186, 187, 188, 189 and 190, your lordship. SLP is pending, your lordship.
The liberty may be granted, madam.
SLP.
185 to 190.
Liberty may be granted.
191.
191, I will seek some time for some instructions.
2 weeks.
2 weeks.
192. Yes. Non-compliance of order dated 5/5/2023. My lord, may kindly turn to Annexure 1. This is a consent order. Your lordship may kindly come to page
Who gave
50.
consent?
Page
Who
50.
gave the consent?
But the state gave the consent.
State, it's very difficult for the state to give a
But your
consent.
lordship may kindly see. Paragraph 5, 6 and 7
Let
of
me
that
see
order.
the order first.
Yes, order dated 5/5/2023 at Annexure 1. Your lordship may kindly, it starts from page 14. My lord may kindly come to page 15. Paragraph 5. Mr. J.R. Khuntia, learned counsel appearing for the respondent number 1 on the other hand, contended that even though the GIA case was allowed by judgment dated 30/12/2013, but the said order is yet to be complied with. It is also contended that the appeal preferred by the state challenging the judgment dated 30/12/2013 in FO number 707 of 2015 was also dismissed by this court by order dated 16/3/2018. Accordingly, it is contended that no illegality has been committed by the tribunal in passing the impugned order because the case, this FO was filed against the order passed in the execution case. Then paragraph 6. In course of hearing of the matter, Mr. S.K. Samal Learned AGA fairly contended that if further time will be allowed to the appellants, they will comply the order passed by the tribunal on 30/12/2013. Then para 7. In view of such submission made by the Learned AGA, this court file disposing of the appeal permits the appellant to comply with the judgment passed by the tribunal on 30/12/2013 in GI case number 574 of 2011 within a period of 4 months from the date of receipt of this order. Then Learned Counsel appearing for the respondent number 1, myself, is also directed to file a petition seeking withdrawal of the execution case in view of the undertaking given by the Learned AGA within a period of 10 days from the date of receipt of this order. Then, my lord, your lordship may kindly turn to Annexure 2 at page 17. I filed an application for withdrawal of execution case and that was withdrawn. Your lordship may kindly come to page 18. I had order dated 13/5/2023. And thereafter, that order has not yet been complied with. And I also filed one interlocutory application in that FO.
Yes.
That is page 21.
Your Lordship, the sole issue here is that the original order dated 30/12/2013, Your Lordship. So that was challenged by the state in FAO number, Your Lordship, 707 of 2015, which was disposed of on 16/3/2018. Against which, Your Lordship, the state has filed a review petition 227 of 2018, which is still pending, Your Lordship. My learned friend had also given a memo for listing of the review petition, Your Lordship. Our hands are tied in the presence of the pending of the review petition.
Then let it lie.
It is stated at the bar that a review application has been filed seeking review of the order dated 5/5/2023.
No, Your Lordship, this is the original order 16/3/2018
16/3/2018.
in FAO number 707 of 2015,
It was dismissed.
which was dismissed.
Which is pending. And the outcome of the said review application has bearing on the present contempt application. So what is the
The review number is 227 of 2018, Your Lordship.
that was passed against which order?
Against order 16/3/2018.
20
16/3/2018, Your Lordship.
In FO number 7,
2018 passed in
FAO number 707 of 2015.
that is the first FO.
FAO number
707 of 2015
by,
by 2015.
no, by which honorable judge?
That is,
Because the review application may be required to be placed before they say, all right. Business matter along with cities also review applications also before appropriate bench after obtaining necessary orders from Honorable the Chief Justice. From or not on the book from the Chief Justice.
193. 193. 190. 193. May I please? This is the order was passed in the second round of writ petition matters.
Second what?
Second round of writ petition. First writ petition was remanded back to the authority. They rejected it and thereafter challenging this, the second writ petition was filed. The order was passed on 1st
193.
March 2024 matters. At page
speaking
page
of
17, page 17 of resume kindly available.
Speaking order, CIS has been
past, Your Lordship,
My respectful submission before Lordship that this order, they have passed this BP order, it is for the sake of rejection only. And in true sense, the order has not been complied. It's a willful violation. Why I am saying so? I am placing the order on SCSC page 17, my lords. Page 17. In view of the aforesaid analysis of text paragraph 9, lords, you got it? As well as legal position and keeping in view the law laid down by this court in Sushant Chandra Sahu's case, this court is of the considered view that the imposed rejection order dated so and so under annexure 5 is unsustainable in law. Accordingly, the same is hereby quashed. Further, the matter is remanded back to the appellate party number to consider the case of the petition appraised in the light of the aforesaid discussion, as well as by keeping in view the provisions contained in OCS Pension Rules 7 and Rule 66, as well as the law laid down by this court in the case of Sushant Chandra Sahu. And in paragraph 7, may draw your lordship's attention for the previous page 16, paragraph 7, the law has been discussed in paragraph 7, my lords, and your lordship will see from the speaking order, the Sushant Chandra Sahu case has not even referred to, my lords. Lordship will see the speaking order.
Yes, Madam.
Lordship, due to the pendency of the vigilance case, your lordship, they have not finalized the pension, your lordship.
There is no pendency, my lords.
There is
What is the reason
pending
order? In the light of this court's order. Where is the reason order, speaking order in the light of this court's order?
provisions, your lordship.
Do you have you passed?
Yes, your lordship.
Where is that?
4/6/2024, your lordship.
File your affidavit, but be careful. If the order is not in compliance of this court's order, then your officers may be in trouble. 2 weeks' time is allowed for the opposite parties to file focus affidavits.
194.
This is just 2 weeks.
Speaking order has been passed, your lordship. A speaking order has been passed, your lordship.
Yes, speaking order passed. Complied with. Yes.
195.
The grievance petition has been disposed of by a speaking order, your lordship.
Please, sir.
196.
Your lordship, the order has been complied by passing a speaking order. Liberty may be granted to challenge the same. Obliged, your lordship.
197.
197.
Some other cases.
This is 196, your lordship.
196. Or 190.
95.
Item 197.
197, a speaking order has been passed, your lordship.
Yes.
Item 198. 197 liberty may be given. 198.
190, the lordship order dated 4/1/2024, it has not yet been complied, your lordship. Your lordship, order is in page 14, your lordship. Direction was given to OP 1 and 2 to consider the pension of the petitioner after the retirement, your lordship. Your lordship seek 2 weeks' time.
2 weeks.
199.
Then passed an order.
Complied with.
Item 200.
200, a speaking order has been passed, your lordship.
Supplemented list. Item number 1, C-206109 of 2022. Item 1 order has been complied. Because all the areas, so also family pension has been granted to the petitioner.
Gratuity has not been paid, man.
That instruction was
Gratuity has not been paid. Family pension and area.
Not paid, shall be paid, because people of gratuity
has been-
was received by the husband, loss, I don't know.
No, husband died.
But I know it. So I will, because 72,000 area pension
No,
and
that
the
has-
family pension rate of 13,000 have already sanctioned into our Milops.
Well,
Which department?
the Water Resources Department.
The petitioner in the present contempt application has alleged disobedience of this court's order dated 21/3/2022, passed in WPC number 6635 of 2022, which was disposed of with the following direction, paragraph 8.
My lord,
Paragraph 8.
my lord, my lord.
Oh. The stand taken on behalf of the contemners that all the post-retiral dues have been cleared / sanctioned. Death come retiral dues. Next, learned counsel appearing on behalf of the petitioner has submitted that the amount of gratuity is yet to be paid.
My lord.
Stop. Next. Considering the facts and circumstances and the nature of order passed by this court, in my opinion, no case of deliberate disobedience of this court's order is made out, keeping in mind the subsequent conduct of the contemners. So stop. The contempt petition is accordingly disposed of with a liberty to the petitioner to raise his grievance, if raise such grievance which is still pending before appropriate authority / forum. Gratuity, you are sure that it has not been paid?
I have no instruction, I have not paid, my lord. I have.
He has been paid 14,77,078 rupees.
In the complaint report, there is no gratuity payment order, my lord, has been
No,
entered.
but you can't say. The petitioners are also be at liberty to raise his grievance relating to computation of the retiral dues. All right. So if there is. That's all.
Item number 2.
Page 16 of the direction given by the General Court, paragraph 7. It was not complied, therefore my lord passed an order on 2nd August 2024, we kindly missing. And after that order was passed, again my lord passed an order on 23rd August 2024, paragraph 6 of that order of my lord Chief Justice. There is a focus reply be filed on behalf of the Secretary Higher Education Department, that is opposite party number 1, as to why content proceeding be not initiated and he be not be punished for deliberate or disobedience of the court's order. No photos have come yet.
Your lordships are pleased to pass that order on 23rd of August, but I have given an order to your lordships. Prior to that, the registrar of the university had written to the secretary, not with regard to the compliance. Now, in response to that is letter dated 25/7/2024 of the registrar bound. In response to that, because on 21/8/2024, the secretary has already given a reply to the registrar, may read out. With reply, I am to direct to intimate that as per the telephone discussion with you on 1/8/2024, it is seen that the petitioners are working in the university, being engaged by the university authorities, being autonomous without following any norm and getting remuneration from the university own funds and not from the government budget. So these petitioners cannot be considered for payment from the government budget. Therefore, it is requested that the issue regarding their service regulation may be examined and considered at the university level itself as an autonomous body and from its own fund in due compliance of the order of the Honorable Court. This was intimated to the registered university members prior to passing out for the order by your lordship.
Who is opposite party number 3?
My lord, I am for the opposite party number 2 and 3, my lord. I have already filed the so-called reply in this case. Just your lordship kindly have a glance to my so-called reply that I am not concerned about this letter. I have taken instruction in this regard, but your lordship kindly have a glance. The so-called reply. Paragraph 12. Paragraph 29, page 12 of my so-called reply. Even after receipt of the notice of this contempt case, the university has also moved the government by stating that not a single post has yet been sanctioned by the government so as to regularize the services of the petitioner. That in this connection, it is submitted that this honorable court, by this order dated 2/8/2012, passed in a batch case, WPC number 15695 of 2011, and WPC number so and so had also directed that if all the petitioners are not selected for appointment, public regularized, then the university shall take up the matter with the state government for creation of posts which were abolished by the orders of the government. So that is the rest of the petitioner who cannot be selected but have been working for more than a decade can be considered for regularization. In this connection, it is submitted that government had abolished many posts of the university, and till today, government has not sanctioned a single post so as to comply with the orders of this honorable court. It is only the consequential vacancy caused due to retirement, death, promotion, and resignation of some employees of the university has regularized the services of 85 employees after following the rules prescribed for the purpose. For which vacancy were there, it is submitted that the present there is no vacancy to regularize.
Please come to paragraph 7. What was the direction?
I know. In view of the above facts and circumstances, we dispose of the writ application with the directions that steps should be taken by the university authority as well as by the state government to regularize the services of the petitioners and expedited as possible. It is needless to say that the necessary recommendation is made by the university authority to that effect, the same shall be considered with a pragmatic view, following the ratio of the judgment of the Honorable Supreme Court in the case of Omadadi as well as the UP State Electricity Board, to plan and necessary order shall be passed in accordance with the law. After this, on the Honorable Chief Justice expressed the concern in the order dated 2/8/2024. Your Lordship can look to my Lord's order.
That we have seen.
Whereafter my Lordship, your Lordship directed on 23rd August 2024. That will be I just order.
Oh, but what is who was required to carry out the order?
The university has submitted the proposal, but that has not been accepted or any action is taken by the state government.
So are they compelled to regularize? There are two questions.
Yes.
One, whether the state government can regularize your service. And two, whether you have a right to be regularized. There are two questions.
Yes, ma'am.
So what state government was required to do?
My lord, the direction was there to the university to regularize. If the posts are not available, they have to make a recommendation of the post which has been to be created to the state government so that the state government can.
So whether the state government is bound to create.
But that will pass some orders, sir. As directed by this honorable court, they have to take a decision on the recommendation given to the university because that's the direction to the state government to that effect. They have not done anything till today, and by this process, we have already got more than 20-25 years.
So whether any decision has been taken on the communication?
That is not given to us.
This one?
Yes. The registrar has been requested by the government to regularize their services and pay them on their own fund because because no norms have been followed while giving them appointment. And the direction of the writ application is in accordance with the Umadir rule.
Yes.
Compliance.
My lord.
Respect, I am thinking myself. Can it be said as a compliance of my lord, sir?
See, unless you demonstrate that it was the state government which had a duty to take a decision. See, if any direction is issued to an authority which does not have the competence to decide, then what that authority will do? No. So you are an employee, you are claiming to be an employee of the university. You want the state government to regularize your service. How the state government can regularize?
State government. State government is the university expressing its inability because the posts are not sanctioned by the state government.
Then there is no question. There is no question. The petitioner in the present contempt application has alleged disobedience of this court's order dated so and so, passed in WPC number 6064 of 2002, operative portion of which reads as under paragraph 7. Stop. Next, when the matter was earlier taken up on 23/8/2024, following order was passed. Stop. Next, and senior counsel appearing on behalf of the petitioner has argued that in utter disobedience of this court's order, and despite the fact that the university had made a recommendation on 3/11/2012 to the state government, state government to take steps to release the abolished posts so as to enable the university to comply with the direction of the High Court, the concerned officials in the Department of Higher Education, Government of Odisha, did not take any action. Stop. Next. Then senior counsel has, however, not been able to point out that the officials of the Higher Education Department had any role to play in compliance of this court's order dated so and so. So stop. The learned AGA appearing on behalf of the contemners has brought to my notice a communication dated 21/8/2024 issued from the Higher Education Department under the signature of its special secretary, the body of which reads as under. So stop. Next. It appears, based on the submissions advanced on behalf of the parties, as also the recommendation made by the university dated 3/11/2012, that the petitioner was working against a post which was not sanctioned. So stop. No sanction. Petitioner has not been able to make out a case that that either the officials of the university or the concerned department of the state government intentionally disobeyed this court's order. So stop. In my opinion, no case of deliberate disobedience of this court's order is made out. The contempt proceeding stands stopped.
And
Yes.
so that they can.
What liberty?
They will move to the university once again and all the things can be brought about. Because this is the letter.
What
that
is your
they
point?
don't need the phone. This letter which my lords have read, that is just now he has handed over in the court. So I had no occasion to go through that. Anyway, since my lord have already passed out, so I do not.
I have quoted the order. I have quoted the order.
Yes.
A copy of the order dated so and so has been handed over to senior counsel in the court. So I make it clear that I have disposed of the present contempt application, as in my opinion, no case of disobedience of this court's order is made out. But I have not gone into the the petition said. What is left? What is left?
Because why not? Since they have the feet of the university and we are all appointed by the university, that's what we have to place before the university that since you have appointed us, you must, and we are continuing for the 20 to 25 years.
So the order which I have passed in the present contempt application is only for the purpose as to whether they should be punished or not. For everything you have liberty. We have not
And
stopped.
they will take the plea that since this other court has already talked, so they all will try to escape and we will be trying.
Dropped means that no disobedience. What liberty? Just dictate the order, I'll accept. I'll sign. I'll give permission for you to dictate 2 sentences. I'll put my signature.
I humbly say that the liberty is granted to the petitioners to move next appropriate application before the appropriate authority. Only 2 lines.
Very difficult.
Because by the we are already succeeded by.
All right, listen to the order which I make it clear that the order is confined to the petitioners to the allegation of the petitioners against the contemptors for disobedience of this court's order. Other questions are left open.
So that they cannot take the plea of minor sort of that.
All right.
Because that is what is.
All right, you have snatched 2 sentences from the court.
Obliged minor sir, minor sir, because we deliver it to.
All right.
My lord, I am for the opposite party number 2 and 3. I am for the university.
All right. That yes, I have seen. Item number 3.
Even if the SLP is rejected against the contempt of my lord. And my lord, kindly come to the page 23, my lord. Honorable Appropriate Directors.
Do you have any problem in standing properly?
No.
Why are you taking this aid of this table? Huh? All right. Yes.
On the relevant page, my lord, 23, my lord. The relevant portion of the order, my lord, the last line, my lord.
Who is for the other side?
My lord, I am from the Board of Secondary Education, my lord. Board of Secondary Education, my lord. The petitioner are already dead. This case was filed against a dead person, my lord. They are not taking substitution, my lord. I have taken instruction from the board.
No, my lord,
They have died, I mean.
the son has filed this petition, my lord. The son has filed this petition after the constituted and taking permission this court.
Petition has been filed by the son.
My lord,
Where is the order?
23 post 23, my lord. The special leave petition is accordingly dismissed. However, 3 months time is granted to the petitioner to comply with the direction given by the honorable single judge, which was confirmed by the reviewing bench of this of the High Court. It is needless to say that.
What was the order?
Post 23, my lord.
Page 23 is the
My lord,
order.
the single bench order, my lord. I have given. I have filed this petition. Filed this order copy and certificate of my lord. 31 July 24, my lord.
Where is that?
The lordship is
Order dated 13/10/2006.
order 19/1/2006, my lord. 9/1/2006. It is judgment, my lord. Date of judgment, my lord. 9/1/2006. OGS number 9254 of 19. 1998.
Just a minute. Nine one 2006.
Hello. Internal page 11, my lord. Paragraph 10. My lord, my lord.
Yes.
Of the foregoing reasons, I allow this read application and that the opposite party to take the total period of service of the petitioner to be 39 years,
When was the SLP dismissed?
my lord. Page 23, my lord.
Yes. So what do you propose?
1 week time may be granted, we will appear and file so called. Mr. Lawyer, Senior Counsel SS Rao will appear in this case. 2 weeks time may be allowed.
Let the chairman be present. Based on the materials on record, I am of the prima facie view that a gross case of intentional disobedience of this court's order passed nearly 19 years back is made out. So stop. Let who is the person?
Ramnaran
Made out. The matter had gone up to the Supreme Court. The SLP came to be dismissed by an order dated
9/8/2010.
19/8 or
19, sir.
9/8.
19, my lord. It is not because the visible, my lord.
9/8/2000.
That's what it is 19, my lord.
Huh?
It is 19.
Page 19.
It is 19. Order dated 19/8/2010.
19/8. This is what I am saying. 19/8/2010.
10, my lord.
Where is that order?
Page 23, my lord.
Nineteen 8/2010. First off,
My lord, it is date 7/1/2011, my lord. This was the writ appeal number. This was the date that the writ appeal was dismissed.
all
Order dated 7/1/2011.
the present contempt application. Who is the chairman of the board?
Torai.
President. My president of the board, my lord.
Who is the chairman?
President. Srikanth Torai is the president of the board.
The petitioner is permitted to implead the present president and secretary of Board of Secondary Education, Orissa, Cuttack, as opposite parties. Must have placed this case on Friday, when the chairman,
President
the president and the secretary of the Board of Secondary Education shall be required to join online. So they shall be required to furnish to this court the names of the persons holding the posts of the president and secretary of the board, right from the date of dismissal of SLP till today for this court to consider initiation of contempt proceeding against all of them. Yes.
Item number 4.
So granted. Time, my lord.
1 week.
3 months.
1 week. 1 week. All of them may be sent to jail. It's a very gross case. It's a very gross case. All right. And there may be 25 persons must have held the position of secretary and chairman or president of the board. All of them will be sent to jail. It's one of the most gross cases I have seen. So you can tell your client accordingly.
No, please, Your Lordship. Item 4. That I have prepared a short date chart. Let's our lordship's confirming the appreciation.
Where is the order?
That the order is at page,
Item number 4.
the annexure 1 at page 10. I have lost that order. Before my learned friend Mr. Sahu goes to the merits involved here, but for my lord's kind assistance, one memo citation with convenience compilation, that I am giving to my lord's firm.
So is the matter so
Just-
serious?
But it's serious. 10 acres of government land, the for that.
It's serious.
No, I say yes.
I filed a detail, 3 additional affidavits.
All right, let us see.
That just now he had served the copy and without giving the, just the reference has been given to me. Apart from
Let me see the order.
yes, Lord. That on 3/7/2015, Demarcation number 24846 of 2014. The order was passed that the prayer in this writ petition is to direct the Tahsildar, PPL, opposite party to correct the ROR.
No, where are you reading?
That I am reading at page 10, Lord.
Yes,
Annexure 1 at page 10.
yes.
That the prayer in this writ petition is to direct the Lord.
Yes.
13/7/2015.
Yes.
The prayer in this writ petition is to direct the Tahsildar PPL, opposite party to correct the ROR in accordance with the order dated 25/10/2010 passed by this court in Demarcation number 14099 of 2009. Direction in the final order in Demarcation number 14099 of 2009 wrongs as under. In view of my observation herein above, the improved order of the additional Tahsildar PPL under Annexure 2 is set aside and the writ petition is allowed. The Tahsildar PPL is directed to correct the ROR in favor of the petitioner within a period of 2 months from the date of communication of the order of this court. The direction was put very specific and to the direction to the Tahsildar that to correct the record of right within 2 months. It is stated by the learned counsel for the petitioner that though 2 months' time had been fixed to comply with the order of this honorable court, passed in Demarcation number 14099 of 2009, but instead of complying with the order, the Tahsildar went on protracting the matter, compelling the petitioner to file the present writ petition. It is stated by the learned additional government advocate that the order passed in Demarcation number 14099 of 2009.
What happened in that appeal?
Well, that appeal has been dismissed and the SLP has been dismissed in the Supreme Court. After this order was passed, this honorable court directed to comply the order passed in 2010 order within 2 months. Thereafter, we preferred this contempt application for due to non-compliance. In the meantime, the state filed a writ appeal. That writ appeal was filed on 11/2/2011.
against judgment passed in the petition which was disposed of in 2010 in this direction. Where the writ appeal then, the writ appeal was dismissed by order dated 25/10/2021. Thereafter, they preferred the SLP before the Honorable Supreme Court.
So where is the order?
Where the order is, order. Yes, additional. We have replied to the additional show cause at flat zero. That was stated in paragraph at internal page 12 to my show cause, my reply to show cause.
So, but why did you file this second writ petition?
Well, the second writ petition was filed because an application was pending before the Tahsildar. Tahsildar was not disposing of that application according to the judgment passed by this Honorable Court in 2010. So therefore, the second writ petition was filed, and taking the advantage of the situation that the writ appeal was filed, writ appeal is pending. So therefore, the second writ petition was filed. And the second writ petition,
Second writ application for the same relief.
but not the same relief.
Same.
To execute the order passed in 2010. But however, the order was passed with a specific direction that the judgment should be complied within 2 months, subject to the result in appeal. Every appeal. Where the writ appeal was dismissed, and thereafter the SLP was preferred against the original judgment.
All right.
That was dismissed. And thereafter, before that, this contempt application was pending.
Yes.
And that is the plea they have taken. Now they have come forward with the show cause, again re-agitating the question which was already decided in that writ petition. First, they are raising that at the time of filing of the writ petition, the writ petitioner was the age of 54. So therefore, the tenant which who had been inducted in 1940, so therefore at that time they are not born. Still was raised in the counter affidavit. Second, it is vitiated in fraud. The induction of tenancy by the other of the petitioner, that was vitiated in fraud. That question was also raised in the petition. And that petition is the question that a revision is pending before the authority. So therefore, this court is precluded to the jurisdiction to consider this writ application. All these questions were answered by this Honorable Court. You also can see the judgment, first judgment. Everything was answered. And thereafter the judgment was passed with a specific direction that you should correct the record of right within 2 months. And that judgment was challenged in the writ appeal. This court dismissed the writ appeal. Thereafter the SLP before the Supreme Court dismissed itself. So in this situation, whether the question which has been educated in the
Aspect of fraud can be gone into at any stage.
But at any stage, but in a proceeding,
Fraud is.
if it has not been answered in the original writ petition, if that question was not answered in the original writ petition, and subsequently it was discovered, then we actually have every jurisdiction to go into that question. And it has been answered in the writ petition. That second show cause.
And who are they who are opposing your?
Government is opposing, the Tahsildar is opposing.
No, Mr. Rath is appearing for whom?
Special engagement.
Appear on behalf of the state, it's a special engagement.
Well, also can see. Well, also can see the second show cause at page 78.
No, where is the order? Earlier order passed by this court?
Yes, ma'am. At page 79, annexure F series belongs. Additional show cause. To their additional show cause dated 17/2/2023 at flat blue.
Why that order is not there in your contempt application?
But the contempt application, of course, that should be incorporated in the contempt application.
So that was
That I am admitting that. But I have been engaged after the first consideration.
Maybe that is a material.
Yes, ma'am.
It is not this thing, but why these facts are being brought to the court's notice by way of additional affidavits or anything?
No, everything has been stated in the contempt application, in the original contempt application and in the
Application C, you cannot say that. Since you are saying that certain questions were decided in the earlier.
I am admitting that because that is a
Where is that?
necessary part of the.
Still, where is that?
But you also can see annex of F series at page 79. Additional surplus dated 17/2/2023 at flag D.
Like
Flag D.
Like B, yes, still there.
Flag D of the rule.
You are referring to annexure F.
Annexure F. F series. At
Annexure
page
F is the
79.
petition.
Running page 79. Yes, flag D.
Like D.
Yes, D of the rule.
Like D is something else.
I'll give you a copy to Matt. My lord, give me a copy to my lord, your lordship, it will be difficult to find out because lot many records are filed. Kindly see from this one, he is giving. See you give.
Some copy of it. Yeah, this is the order. Well, as you can see. Then also can permit me to place that. But you also can see the paragraph 7. What is the stand in that petition? That is the order. In that petition, you also can see paragraph 3 at page 82. Paragraph 3 of the internal page 3. I will permit to close that.
Yes.
The order dated 18/4/77 passed by the Tahsildar PPE under Annexure 1 reveals that he had invited public objections by beating of drum, called for report from the RI, and apart from that, he had himself made field inquiry.
We are reading.
Let paragraph 3 of the judgment. Paragraph 3 of the judgment.
Yes.
The order dated 18/4/1977 passed by the Tahsildar PPE under Annexure 1 reveals that he had invited public objection by beat of drum, called for report from the RI, and apart from that, he had himself made field inquiry on 25/11/1976 on his administrative side for his own satisfaction, and he has personally taken statements of the local villagers to ascertain the genuineness of the claim of the petitioners, and the local people stated before him that the state plots, that the suit plots are in khas possession, being cultivated from the time of their forefathers, and the villagers have no objection. The Tahsildar, taking into consideration the documents like the Expedited.
So why are you reading? See.
But this is my case, and there are
What is the finding of the court?
Yes, ma'am. The finding you also can see at paragraph 9. That the paragraph 9 with regard to fraud law, the court has dealt with the aspect of fraud in paragraph 9.
Yeah.
From the order sheet under Annexure 1 filed by the petitioner, I find that he has filed rent receipts and quota issued by the ex-intermediary, and as for the order dated 3/2/1976 of the Tahsildar, the same has formed part of the record, and in his order dated 24/7/1976, the Tahsildar PPE has recorded that he has verified the report of the RI, which says that the petitioner is in possession since the days of his father, and from the journal record, it appears that the ex-intermediary has admitted the petitioner as a tenant, and the ex-intermediary has granted for that in favor of the petitioner with effect from 1940, and the rent is granted by the ex-intermediary on verification has been found to be correct as per Jamamandi from order dated 18/4/1977, asked by the Tahsil.
Do you say that the plea of fraud was considered by this court?
Yes, my lord, hence the decision relied on by the state reported in 1994 Supreme Court, so and so, and others have no application because of failure of the opposite parties to produce the record to prove the contrary, and even no inference can be drawn with regard to fraud.
All right.
And thereafter, you also can see that another objection has been raised in the so-called that since it is not voucher property, so therefore it could not have been settled in that land. That has been dealt with in paragraph 10 here of the judgment.
Yes.
The Honorable Court has come to the conclusion that since the prohibition to record the voucher property has been came in Act 1 of 1848, and it is a induction of the tenants in 1940. So therefore, there is no prohibition for induction of the tenant in respect of the voucher property. That is the finding of the Honorable Court. Then we have to regard to the revision. The revision this court has dealt with in paragraph 12. That the Honorable Court has observed the opposite party could not file any document to falsify the claim of the petitioner. So far as filing of the revision case is concerned, the same is definitely an act of afterthought, and the same has been filed during proceeding before this court. That too after lapse of 33 years, and no reasonable and a logical explanation is forthcoming justifying the action after such a belated stage.
Yes.
By observing all this blood with these findings, this Honorable Court directed in the last part of the judgment your lordship can receive. In view of my observation, herein above, the interim of the additional Tahsildar PPE under Annex 2 is set aside and the petition is allowed. The Tahsildar PPE is directed to correct the record of right in favor of the petitioner within a period of 2 months from the date of communication of the order of this court.
Yes.
Yeah, this is the specific direction of this Honorable Court. And they have raised this by filing 3 so-called affidavit, and in additional so-called another ground was taken that since at the time of filing of the writ petition, the original petitioner has shown his age as 54. So therefore, since he was taken a plea that he was inducted as a tenant in 1940. So therefore, at that time, he was not born. That is the plea was taken in the counter also. But replying to that, we have filed a case before this Honorable Court for amendment of the cost type. That actually my age is 84, not 54. That is a type of mistake. But application was filed, and that application during the very tendency of the writ petition. So therefore, this court was fully conscious that the plea which was taken, that was not correct.
What is your age now?
But he has already died here. At the time of filing of the writ petition, he was 84. Thereafter, his legal rights have been substituted.
In this case, you have been substituted.
Yes, all the legal rights have been substituted. Like in 2016, the contempt application was filed.
So where was the substitution filed?
Where this substitution was allowed. We have given the consolidated cost title. But that was admitted chapter. But this court, in the contempt application is allowed. By order of this honorable court in contempt application.
When?
I place it. But we just have to know that this court is allowed. But it's for 2021.
Year number?
445 of 2021.
4-4?
445 of 2021. Substitution at flags. Substitution allowed. But the consolidated cost title taken on record on 26/8/2022. Exactly, order is not.
Year number 455 is where is your substitution application? 445.
At flag C perhaps that they do.
Yes, it is there.
Yes,
Year number 445.
yes. Not that. So government of 2002.
So on 8/1/8/11/2016 he died
Yes,
at the age of 91.
at the age of.
Yes.
Yes.
And you filed this application 6 years thereafter,
What?
5 years thereafter.
What
For
is
impediment.
substitution application?
Yes.
No, we have filed it in 2016.
No, you filed the substitution petition in 2021.
But that is allowed by this honorable court. We are allowed by this honorable court and they have been substituted. So it should get back to the date the application was.
Where is the order?
But I'm sorry that order is not with me.
But it must be there with me. Yes, order number 6. Make your submission.
So therefore, we are now in this situation, we have everything, the fraud has been considered, the filing of the application under the revision has been considered, the appeal of the settlement of the voucher line has been considered, everything has been considered and the finding has been given by this honorable court. After giving this finding, and they have filed the counter also. In the counter, all these things was raised. And the honorable court has referred to the counter. So therefore, I am placing before your lordship in paragraph 4 of the state counter. What exactly the plea they have taken in that counter? And everything has been answered.
They might have violated the order. Question is of punishment.
But the punishment. So therefore, at this juncture, I am citing one judgment of the Honorable Supreme Court.
Yes. What punishment? See, according to you, the order was passed in 2009.
2010. Yeah.
2010.
What I'm suggesting, Miller, in this contempt application, we have annexed one miscase, Miller. The Tahsildar, we filed after the second order was passed in the petition, we filed the miscase before the Tahsildar. That is stated to be under Rule 34 of the Survey and Settlement Rule. Because if a judgment was passed by the competent court, the Tahsildar has the jurisdiction to correct the record of right on the basis of that judgment.
Sir, counsel, that is not the question is.
Why am also can allow this? You also can see the contempt application. They have filed an application that is miscase number 29 of 2015. I have also annexed in the contempt application. You have no intention to punish the Tahsildar.
Then you don't have any intention, then you can't pursue. That is the only purpose of contempt of court side.
And you also can direct the Tahsildar to comply with order.
That I will not do. Never.
And so therefore, for
that is beyond the jurisdiction.
for that purpose, I am one subject to your lordship's acceptance. I am suggesting that Tahsildar has passed an order in 8/2016 in our application. We have annexed to the contempt application. What the Tahsildar has said, because the writ appeal is pending, but there is no instruction from the government. We have sought for the instruction. So therefore, at this stage, I cannot pass the order. And they say, so case is still remain pending for final decision. That order will be passed by the Tahsildar. May I suggest one thing before your lordship? That application which is pending before the Tahsildar, let the Tahsildar take a decision on that application. That is, we have got it with the notice of this on the report.
That is open. Yes, Mr. Rath. He is not pressing the contempt application.
Right.
But he is just saying that he will pursue the matter before the Tahsildar, where the matter is pending and Tahsildar is yet to pass an order.
And that application is still pending.
34 application, that will open up another facet of the litigation.
No, see, what will open up what we are not concerned with.
Yes.
Right. If he says that he will not press the contempt application.
Not press. I'm not saying that I'm not pressing. Contempt application in these circumstances. He was
Just a minute.
I'm so just a minute. I'm so sorry. Since we are not, I am not saying that I am not pressing the contempt application here. It is a fact. The fact remains here. The order of this undertaking has not been complied with. And it is a positive direction of this undertaking to a particular authority to correct the record of right. And against that, they prefer the writ appeal. Writ appeal was dismissed. I am not repeating that here. So therefore, the fact remains the order of this undertaking remain on the remain. Not complied with. So therefore, I am leaving it to your lordship. It is a clear case of contempt. It is a clear case of contempt. So therefore, the question that they are now raising, that is structuring to the merit of the case. Once the merit has been decided, and I'm just placing one decision of this under report for your lordship's appreciation. That is 2002, 5 SCC 352. That is the scope in a contempt proceeding. Well, also can see page 5, paragraph 11. I'm placing. Paragraph 11.
Yes.
What I'm placing. The purpose of contempt jurisdiction is to uphold the majesty and dignity of the courts of law, since the respect and authority commanded by the courts of law are the greatest guarantee to an ordinary citizen, and the democratic fabric of society will suffer if respect for the judiciary is undermined. The Contempt of Courts Act 1971 has been introduced under the statute for the purpose of securing the feeling of confidence of the people.
Yes, yes.
But thereafter, the lordships have also said that in a contempt proceeding, the merit of the case cannot be done in.
Absolutely right.
Only the direction which has been given, whether it has been complied or not, that is to be looked into it on the report. That is the law.
And your lordship is very often day and day out expressing that way. If the contempt is made out, then there is a punishment. Only remedy is punishment.
Yes. And no other,
No other remedy. Your lordship is saying.
whether the contempt petition is to be done.
Since a person was fighting out the litigation for so many years now, your lordship also to look into that aspect.
All right. Subject to what is, yes.
Whether your lordship will, I'm fully ready to assist my lord. Your lordship will find all throughout, I'll only confine myself to the allegation of fraud. And I'll establish it with demonstrating the materials on his affidavit, how he has played fraud by misrepresenting facts all throughout, starting from 77 till date before my lordship. Lord, order was passed, order which he is trying to implement initially was passed on 18/4/77. 1926, this property was recorded in the name of the state. There are records I find. 1966, property recorded in the name of the state as butcher. 1988, even after the order 77 was passed, it was
The
recorded.
question is whether now.
Right. No, Lord, that
In the
cannot be,
proceeding,
Lord, I will confine it to the fraud only, Lord. I am not reopening in any manner in the facts, Lord. Facts cannot be reopened, my Lord. Lord, only thing is that your lordship will find what he does is after 77, 28 years after, he is approaching this honorable court in 2009, asking to implement 1977 order. Just quickly, I'll tell the facts, Lord, quickly, very quickly, in 2-3 minutes. But 77 order he has made. 28 years after, he is approaching for the first time to implement that order. Now, this honorable court passes an inner course order, go and approach the Tahsildar in a representation. Tahsildar rejects it. Now, in 2010, he files a writ petition. Your lordship will find 2009. Your lordship will find not only in 2009 writ petition, in 2014 writ petition, in and in a sale deed executed by himself, his voter ID, his voter list, where on his affidavit, ages he has shown at different points of time on affidavit in this honorable court, he was not burned. The petitioner was not burned even on 1140, but claims to be a lease deed in his favor, permanent lease deed in his favor. And on that basis, he has been claiming to record 10 acres of government land in his favor. But that is an apparent fraud. Now I demonstrate it referring to records which are filed by your petitioner.
So whether this plea of fraud was taken earlier or not.
But question is not, though in the counter it was stated, but the honorable single judge for lordship will see that has not been considered at all.
Then we cannot go into.
The lordship is not, that's right, lordship. One more intervening aspect, that 77 order which relying upon member board of revenue in exercise of power and section 38 in the year 2016 has already set aside that order. That your lordship is to consider, that's a development in between. Before the judgment is passed in 2014 matter, the order he is trying to enforce is set aside by the member of board of revenue under section 38B, which has attained finality. He has not challenged that order. Kindly see that judgment passed by the member board of revenue under section 38B. The order which he is trying to enforce through contempt application has already been set aside.
Order passed by whom?
By the member board of revenue. Tahsildar.
Order passed by Tahsildar. So order passed by Tahsildar was approved by this court. In 2010.
Correct.
If that was approved in 2010 by this court, then how could the revisional authority reflect that?
All these issues, revisional authority is an independent jurisdiction, man. And it was open for him to raise this issue before the revisional court.
No, it was open for you also.
Obviously,
it was the revisional authority must be ignorant of the fact that such order.
That's only a fact, I am just bringing to my lord's notice, my lord. The revisional authority, since it's a very valuable piece of government land, that's right.
Maybe.
That's right. But member had set aside that order directing settlement of the land in his favor. That order still holds sweet, has not been set aside, nor has been challenged anywhere.
So if we have two orders,
Yes.
If you have two orders before you,
Which
one
one
was by the High Court and the other.
Right one. Obviously not the, but I cannot say
Yes.
that the member will override this on the High Court, no. But then I am just bringing, this is the issue, but for that, if Lordship sees, even assuming that it was taken a plea in the counter. Now kindly see what the Honorable Single has said on that, and my writ appeal was dismissed on the ground of limitation. It was not decided on merit. My SLP was dismissed without giving any finding on that. It was not decided on merit. And today, we have also filed an application to recall that 2010 order, which is pending for the appropriate bench. That order, which sought to be implemented, that we have applied for recalling that order. One IA is filed on the basis of liberty granted by the writ appeal court. This honorable division bench of this honorable court granted us liberty that you raise this issue before the appropriate authority. I mean bench. We have filed a recall application on the ground.
When did you file?
But filed in the after disposal of the writ appeal and SLP, we approached this honorable court in writ appeal. 5/12/2022. Yes. 5.
So the liberty was granted to you by the Supreme Court?
No. By the division bench in writ appeal, this honorable.
In the writ appeal, all right. In the writ appeal, you were granted liberty. But against that order, you went to Supreme Court.
No. Dismissal order. Our writ appeal was dismissed on limitation. We went to Supreme Court. Also court dismissed our SLP. Now, after having lost there, we came before this honorable court on these grounds of fraud were detected. We approached the writ appeal court. Look, there are fraud. So kindly allow us to take some recourse to this. The honorable division bench permitted us to raise this issue in the appropriate forum. We have filed an application for recalling. That order is placed 26 of May, convenience compilation.
All right. Third, also, yes, on next.
But it is closing of
Next Friday.
next Friday.
Item number 15 is for original.
Next item 15, most Friday, I have some difficulty.
I have difficulty that I have poor memory.
Because we are another way.
It will be there, I'll adjourn. That will refresh my memory.
No, my Leonard cannot have both the cakes. He will have the cake here and cake somewhere else. No, not somewhere. I'm saying. It is not I'm saying. You don't have.
It will be there on next Friday. Yes.
Mr. I said in the light, I will explain.
Item number 199, order has been complied. 199.
Well, item 7, I did 4 weeks time because the ministry has examined this and we lost the case in Supreme Court.
So item number 7 is what?
In supplementary list.
Item number
Contempt number.
What do you want?
I need that after 4 weeks.
All right, next week I'll see.
I don't know 9, my lord. I don't know 9.
item number 65 million, that state council has been taken time 2 weeks for today to give the instruction. And this is the matter of a sole distress woman. And it is a sole distress woman, Millard. It is necessary that may be kindly taken up on Monday because it is too late today.
Monday, contempt matters cannot be taken up.
Special ground, Millard, because she is starving, the payment is not made by the person who is staying as tenant. And it is necessary that she meets on Monday this matter.
What can be done? What can be done?
On Monday,
Friday.
yes, Millard, on Monday.
Wait till Friday, make a mention on Friday in the morning. They'll
Obliged.
just let me know.
My lord, item number 9.
Just
My lord,
160 permitted to order.
I don't know 9, my lord. One item deleted, content number 98718. Out of 3, 1 has been deleted. Let that matter come.
all right.
3 items listed. 1 is deleted. Number content number 98718.